Have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, as usual, for that rousing cry. Good morning, everybody, and welcome to the session of the Appeals Court for April 10th, 2024. We are in courtroom 4, the Alan Hale courtroom, named after the first Chief Justice of this court. There's another session going on in courtroom 3, so make sure you're in the right place. I'm sure you are. Your panel today is me. I'm Greg Massing. We have Justice Englander, Justice D'Angelo. We have read all of your briefs and the materials, so you can jump right into it. Each side gets 15 minutes. I don't have to tell you. No rebuttal. And with that, I'll call the first case, which is 23P633, Commonwealth versus MELO.
Morning, Your Honors. If it pleases the court, would you mind if I took the second issue first, the poll camera issue?
Go right ahead. We'll redirect you if we want to go somewhere else.
If it pleases the court, I think in this case, it's been established under Mora that the defendant had a reasonable expectation of privacy. The issue that's of concern is whether the Commonwealth had probable cause at the time of the installation to install a poll camera. I think that if I was to point to one thing that I had the biggest concern about is the Trooper Massey's affidavit, poll camera affidavit. There was very little about the informant, his reliability, his veracity.
Counsel, can you hold on one sec?
Yes.
The light has not gone on. Oh. Sorry, Judge Massing. All right. Sorry about that.
Oh, that's okay.
Thank you.
So, when I look at the second prong of the Aguilar-Spinelli test.
Why are we talking about the confidential informant at all?
I'm sorry?
Why are we talking about the confidential informant at all when we're talking about probable cause? Which time period are you talking about? The poll camera was first installed, I believe it's December of...
I think in November 2018.
November 2018. They installed the poll camera at that time.
Yes.
They have had... okay, at that time, the only controlled buys were with the CI, right?
Yes, there are two control buys.
But haven't we had, at that point, the trooper has observed the transaction from a car?
Well, the transactions took place, I believe, in the house at that time. The first two, I think.
Well, yeah, she may not have observed the transaction, but
Yes.
the controlled by, there've been at that point two or three
Two
controlled buys.
yes, Your Honor.
That the trooper has been present at and has managed.
She was in the car, yes, Your Honor.
Well, she's more in the car. She does what they do in a controlled buy, right? She says, "Here's your money," and the money's gone, and there are drugs instead, right? And the person is searched before they go.
Yes, Your Honor.
So why do we care about the CI at that point? The trooper has.
Or to put it differently, hasn't the veracity of the CI and reliability been shown by the controlled buys?
Yeah, that's the issue I have.
Right? Is that the question?
Well, no, actually.
Okay.
But that's a good question too.
Okay.
I mean, if you look at the poll camera, I'm going to call it the poll camera affidavit. I think it's referred to as a supplemental affidavit. The only thing about the informant is that the Lynn police knew his whereabouts, and it's very thin. There's nothing about any.
But there are two controlled buys that establish, I mean, the law is case law is very clear that controlled buys can establish the veracity and reliability of an informant.
Yes, Your Honor, but I would expect that, when I read the affidavit, it seemed like what they said about the informant was just perfunctory. It was just boilerplate that, the police knew his whereabouts.
You don't happen to know off the top of your head or right there what the record site is for that affidavit?
The affidavit said, it said the CI's name and whereabouts
I
are
want to
known
look
to the Lynn
what
police.
page is it on?
I've got it.
Oh, I'm
Here,
sorry.
hang on. So it starts at 119, I believe.
Appendix 119?
Yeah.
Thank you. Okay.
Got it?
So it's the search warrant affidavit. The search warrant affidavit?
I'm sorry.
The search warrant affidavit?
Yes.
Okay.
I can read it to you. I have it here if you'd like me to read it.
Got it.
Okay. So if you read that paragraph, that's all they have to say, all Trooper Mancy has to say about the informant. I understand, like, obviously his name is not there. There's nothing about the informant's past cooperation with the police. There's no information about his reliability, and I understand that independent police corroboration can make up for part of that, but I don't think it can make up for the entire veracity prong. So I think that, that's the problem I have with probable cause and then the decision made by the trial court.
Can we talk about issue one?
Yes. Under Bonet, there's that first phase, there's two parts. I think the first part is that, it's harm. The Commonwealth has to demonstrate harm to the informant. And, if the informant's identity was disclosed, it would hamper future police efforts with that informant. Well, the cases I read, it seems as though, again, there's not really enough there about the actual threat. There's just a very thin line about a supposed
The request
threat.
that's made in the discovery motion, I might agree with you if the motion was looking for information that maybe didn't disclose the identity of the informant. But the motion itself is asking for the name, the dates that the buys took place, his prior track record with the police.
Yes.
The case law is pretty clear that it can be inferred, depending on the circumstances, to the danger to the informant. How could this not be a danger to the informant if you're giving the name, the dates, and the track record? It's certainly going to identify who the informant is and danger to family, wouldn't it?
Well, yes, Your Honor, but, the cases I read, it said you need to have some explanation of an actual threat, that a supposed threat, a theoretical threat is not enough, from the cases I read anyways. And
What case would you rely on for that proposition? Where would you point us?
if I can refer to my notes. I'm sorry, I can't find that. Let me see. It's McGrath, Commonwealth versus McGrath, 364 Mass 108. It's a 1973 case. Yeah, in that case, the court said Commonwealth failed to show any specific threat.
Okay.
And has not proven that disclosure would impede the law enforcement efforts. Normally, that case goes on to say, normally, an actual threat needs to be shown beyond pure speculation.
Can I ask some, I don't want to say procedural posture, but maybe some timing posture? The motion for discovery was made for purposes, it seems like, for a motion to suppress.
Mm-hmm. Yes,
In
Your
the Commonwealth's opposition, they make a mention that they are not going to introduce any evidence, basically, regarding the CI at trial.
Honor. Yes, Your Honor.
Ultimately, they do, and we'll get to that with the Commonwealth. But prior to trial, was there ever any discovery provided to the defense that the Commonwealth had changed its mind and was going to introduce any information regarding the CI at trial?
Not that I've seen, Your Honor.
And so, therefore, there was never a discovery motion filed immediately prior to trial by the defense asking for this information?
Not that I'm aware of, Your Honor.
Because that is a different posture. The cases talk about the motion for discovery for pretrial purposes versus trial purposes. You would agree with that's what the case law
Yes,
says?
Your Honor, of course, yep.
Okay.
And then I think the second part of that first phase is that it had to be, the information on the informant had to have some kind of materiality to the defense. And I think that...
So how does it when the defendant is not charged with any of the transactions that the CI was involved in?
Yes, Your Honor, and I think that the trial court made it clear that, you know, the informant wasn't a recipient witness. But when I look at the case...
So, I mean, I really want to understand, like, how would the defense have used that information to contest these indictments?
Well, I think, you know, at trial, I think that defense counsel would have been certainly a credibility issue.
I mean, why is the CI's credibility at issue when they're not a witness to any of the?
Well, I think the credibility of I mean, in my view, the informant was more than an informant. He was really an instrument used by the police to get this whole case established. So I think that's, you know.
Well, you know, you used that. I looked at the case where you got that instrument language from. It's a 1955 case from the Fifth Circuit, Port Domene, and it says that the CI was an instrument in making the purchases. Quote, "The informer is the person to whom the defendant is said to have sold and dispensed the opium described in the indictment." So that person was actually the person who bought the stuff at issue.
Charged conduct. I understand that, but and I understand the point you're trying to make.
So I mean, how would that, if you'd undermine the credibility of the informant that got the whole thing started, which was credibility was confirmed by controlled buys, how would that have worked at trial?
Well, I think that counsel would have also examined on, you know, the identity of the seller of the drugs. The CI was the only person in that house with the seller, with the defendant.
Not with respect to the charged conduct, though. The point that the judge is making is the CI was not in the house with respect to the charged conduct. The charged conduct was all transactions that took place with a trooper.
No, I understand that, but it seems, well, and again, I'm sorry to repeat myself, but I think that without the informant in this case, there wouldn't have been a case. The police wouldn't have been able to, develop this case. And I think that, the ability of counsel to cross-examine the defendant at trial, you would have gone to not only credibility, but who he bought the drugs from. He was those two were all alone in that house. Who was the person who sold the drugs? I think that's still unknown. Only the CI knows that.
So I understand that the Commonwealth ended up using some of the earlier controlled buys as like prior bad act evidence.
Yes.
So it would have negated the prior bad acts. Could have. Maybe.
Yes, but again, I think that aside from the fact that the informant was not a recipient witness, I agree with that, but he was certainly an important instrument in this whole case.
Okay. No, I think I understand what you're saying. Yeah.
Anything else, Your Honor?
Nope. Thank you. Yes, there's no penalty for finishing early. Yeah.
Thank you.
Good morning, Your Honors. May it please the Court, Assistant Attorney General Tara Johnston on behalf of the Commonwealth. This Court should affirm Mr. MELO's convictions for possession with intent to distribute and for trafficking in fentanyl because, one, the motion judge properly exercised his discretion in denying Mr. MELO's motion for disclosure of the confidential informant, and two, the Commonwealth properly denied Mr. MELO's motion to suppress the poll camera evidence.
Counsel, in the Commonwealth's opposition and ultimately in the judge's conclusion, the Commonwealth says that it's not going to introduce any evidence regarding the controlled buys with the CI. But then they do. So the motion judge was under a belief that the CI really wasn't relevant to the underlying case. So how do we deal with that when it seems that you changed your tune at some point prior to trial or during trial?
Your Honor, I believe that information about the CI, the control buys, was offered to give the jury prior, just a background of how this whole, everything happened.
The background came in about 7 different pages, and again, whether it's for background or whatever, it is different than what they told the motion judge. A motion judge was acting under a belief that the CI was really not even going to be mentioned at trial.
I understand, Your Honor, but that was actually not the reasoning that the judge provided for the reason why he found that Mr. MELO had not adequately challenged the informant, the informant privilege here. The reasons that the judge gave was essentially because that the CI was neither a participant nor a recipient witness to any of the controlled buys.
Well, can make a statement during argument, and if the judge doesn't seem to be relying on that, then they can just change their mind at trial and do it differently?
Your Honor, I know that part of the defense argument at trial was to actually try and show that the Commonwealth's case wasn't very strong because of the CI and because the CI had later given information about the drugs being hidden in a certain place in the curtains of Mr. MELO's apartment, and that turned out not to be accurate. I don't know if that was mentioned at all in defense counsel's opening statement. I am not going to say that it was. I can't speak to that, but I know that was part of the defense at trial, at trying to show as part of the theory of defense that, even though the theory of defense at trial was misidentification, the defense did try to show, that was part of the defense, that the CI was not reliable here.
Defense counsel in his opening makes one sentence about the confidential source. and before they even set foot on the property, they got a tip from a confidential source who said it was Mr. MELO, Sterling MELO, dealing drugs. In
Yes,
a three-page opening, that is the only mention of the confidential informant, and you're saying that statement, which is an opening, which is not evidence, opens the door to the Commonwealth completely changing its tune and saying, okay, now we're going to introduce a lot about the CI.
Well, Your Honor, there was no objection to any of this testimony about the background. So not only does the defense open the door, but there is no objection to this at trial. And regardless, the test is still the same.
Well, it's not, is it? The test is right pre-trial, and the cases talk about the test because of a motion to suppress. But every case talks about it is different if it's for trial purposes. If the defense is not challenging or the Commonwealth's not introducing anything at trial, to me, that language sort of says it's irrelevant. The case is about the controlled by with the police officer. It's not about the CI. It seems like the Commonwealth changed the...
Even if they did, Your Honor, even if to some degree that is true, I don't think it changes the fact that here the motion judge was correct in the finding, regardless of whether or not that additional information came in or not about the CI. I don't think it changes the fact that there was a properly asserted informant privilege here, and the fact that it isn't adequately challenged, because the fact of the matter is that there is nothing that could have been added by having the disclosure of the CI's information.
Counsel, I'm with you. I don't want you to think I don't follow your argument. Pre-trial, let me say hypothetically you're correct. But during the trial, the Commonwealth does introduce stuff about the CI, which puts that CI, his or her credibility at issue. And counsel, although it's not an objection, he asks to go to sidebar and he says, I asked for the CI's identity and I wasn't given it. Therefore, I don't think this evidence should be admitted. I mean, it doesn't say objection, but it's kind of like an objection. So are you saying that if defense at that point in the trial had said, I want the information regarding the CI, he would have been entitled to it?
No, Your Honor, because it still would not have been relevant to the fact, because the fact of even though this was introduced, it was introduced as background evidence, Mr. MELO was still not charged with any of the crimes with which the CI participated or was a recipient witness.
What is your best case that says, if there is one, that says if it's only introduced for background information at trial, the defense isn't entitled to it?
Well, I don't know that there's any case that says that it's only introduced as background evidence, but the Commonwealth does cite a couple of cases in its brief, Commonwealth versus Connolly, Commonwealth versus Clark, where it's made very clear that if the CI is not a participant or a recipient witness to the transactions, then the disclosure is not, there is not an adequate basis for disclosure.
I don't think that overstates it. That's inconsistent with the opinion that Judge D'Angelo wrote for this court less than 2 months ago, where there weren't a recipient witness to the actual crime, and yet the evidence with respect to the CI still could have been relevant to the suppression hearing. So you overstated it, I think, there.
I'm sorry, Your Honor.
Let me ask you this. Your opponent says that there has to be more than what was given in this affidavit in order to satisfy the Commonwealth's burden of showing that the CI's name or identity shouldn't be disclosed. And in particular, he says there has to be some specific information about a threat. What do you say to that?
Your Honor, I would say, so I referred this case to Commonwealth versus Johnson, where the Massachusetts appellate courts have recognized that there are certain circumstances where the threat is inherent in the circumstances of the case. So yes, while we often look for a specific threat, sometimes it's inherent in the circumstances of the case. And this was one such instance, and the question is whether the judge acted in his discretion in finding so. And we look at several factors that support such a conclusion.
What were the facts in Johnson that made it inherent?
The court noted, and there weren't, I don't know that, I think the court was noting in Johnson there are some circumstances that are inherent. And also in Commonwealth versus Holiday, that was a protective order, and the court found that in that case, it was stronger, that there was murderous feuds, and there was, so but that doesn't set the threshold.
This seems to be sort of a pretty, I mean, this is sort of right in the wheelhouse of why a CI is used all the time in this Commonwealth, right? To tell somebody about drug transactions.
Sure, but
Is it the Commonwealth's position that any time the CI's information is used in connection with apprehending a drug dealer, that it's inherent in that
No.
there's a threat? Well,
No,
then
Your
why
Honor.
is this case different?
No, Your Honor. There are several factors that the judge considered. One, this was a known Lynn drug task informant, and the logical inference from the affidavit was that this informant had provided information to the police regarding in several other cases. Another factor was that this CI specifically, there weren't multiple CIs. This CI was essentially integral to the investigation, and was essentially the impetus for the investigation. The CI was the one who came forward with information that Mr.
Why does that matter to whether or not the government has carried its burden of showing that it doesn't have to disclose his name? The fact that he was integral to I mean...
Well, because it shows that it could have posed a serious risk to the informant, and also the seriousness of the charges.
His involvement, there was enough knowledge of his involvement that one could infer that his identity could be more easily discerned from any further information? Is that the argument, basically?
I think the argument is that having that information could put him at risk because of the fact of what an important part he played in the investigation, and the fact of the seriousness of the charges that Mr. MELO was facing. Although Mr. MELO ended up just being indicted on indictments 1 and 5, he was facing three indictments for possession with intent to distribute, and 3 indictments for trafficking in fentanyl. The trafficking in fentanyl carried up to a 20-year sentence with 3.5-year minimums. The possession with intent to distribute carried up to 10 years. If he had been convicted on all the charges, I mean, he received consecutive sentences, he could have theoretically been looking at up to a 30-year sentence or more.
Counsel, I think what Justice Englander is getting at is the three of us have seen a lot of affidavits for search warrants. There's not much different in this affidavit as far as using a CI, makes controlled buys at a certain location, sometimes they say, that makes this any different than any other case. And it seems to me the Commonwealth always, perhaps rightfully so, says you can infer from these 3 controlled buys that there's a danger. And we're trying to, or I'm struggling with, has the SJC basically said it's almost always you can infer it, and that's that?
No, Your Honor, absolutely not.
So what is specific in this case? Right now you've talked about 3 things. It's a known CI in Lynn, integral to the investigation, and the seriousness of the charges. Is there anything else that makes this case different than any other case we see?
No, Your Honor, and again, I think it's the Commonwealth's position that the judge acted within his discretion in finding that it was self-evident. But if this court disagrees, and I understand this court's points on this matter, if this court were to disagree, then it comes down to whether or not, essentially, it's harmless error. Because if the Commonwealth finds that the Commonwealth didn't establish an informant privilege, then there is no need for a Raviara balancing test. It's only when both answers to that are the affirmative that you get the Raviara balancing.
I'm not sure that law makes sense to me, by the way. I think you're right. But even if you didn't establish whatever that threshold is, if there's nothing that indicates that the confidential informant's information was materially relevant to the trial, then I don't know why we would be reversing the result of the trial. I agree, though, that you could read the case law that way. I'm sure you don't disagree with what I just said.
Right. Right, and
I know that you do agree with Attorney O'Meara that the CI was integral to the investigation.
I agree that he was integral to the investigation. I don't agree that he was integral to the charges at trial. So I think that there are 2 different questions. I absolutely agree that he's integral to the investigation. But as with related to the charges, that the actual charges at trial, Mr. MELO would have been convicted regardless, because nothing that the CI could have offered at trial would have done anything to assist the defense here, where he was neither a participant nor a recipient witness. He could not have put into question the credibility of the undercover officer at trial, and so there was nothing that the CI could have offered that would have assisted the defense in this case. And therefore, even if this court disagrees with the judge's decision here regarding disclosure, it is harmless. I'm trying to, oh, sorry.
You want to talk about poll cam?
Yes, I don't have a,
So do I. So, because we're running short. If you
I
don't
do
mind me
see
going.
that, yes.
So, there's, the poll camp's put up in December of 20, whatever.
November 30th, 2018.
At that time, there had been 2 controlled buys,
Correct.
each of which the CI had participated in, right?
Yes, correct.
Okay. And is it the Commonwealth's position that at that time, they had probable cause without the use of the reliability, veracity of the CI?
I think at that point, the reliability and veracity of the CI had been proven, because during the second control buy, the undercover officer was actually present, and she actually saw the same person that they had matched with the RMV photo. Yes.
Home, right?
Yes, Your Honor, yes. So I believe that at that point that they installed it, it was absolutely established that the veracity and the knowledge and the veracity, the 2 prongs of the Aguilar-Spinelli test for the CI.
What about the 6-month gap there?
Yes.
Does the camera keep going?
It does, because it does keep going, because this case was decided before Commonwealth versus Mora, before the court had decided that it was a violation under Article 14. So
is it being recorded the whole time, or is it just somebody can look at it simultaneously?
I believe it's being recorded the whole time, so it's there the whole time, but none of that evidence comes in from that 6-month period. And the time from which it does come in, from July to August, where those other control buys are happening, the probable cause was reestablished, because in June, Mr. MELO reached out again to the undercover officer, saying that they had good drugs, and then July 23rd, they agree on the sale, the sale. So before evidence comes in, again, evidence is only coming in from that poll camera of the actual incidents themselves. It was reestablished at that point.
Got it. Yeah.
Again, in that point, the court had, and I know I'm very, very short on time here. But
you're past time.
I'm past time. I apologize. But I just want to clarify that I want to make clear the standard. I know this court well knows it, but I want to reiterate that the standard under Mora is very different than I think what Mr. MELO is understanding it, or my colleague is understanding it to be, which is that it really is probable cause that a crime is being committed. Not who is committing it, but a crime is being committed, or has been committed, is being committed, or is going to be committed. And they had probable cause to believe that was happening at a 79 Holland Avenue based on the control buys. And then the next prong of it is whether or not the poll camera will facilitate in procuring further evidence of the crime, or assist in apprehension of the person committing the crime. And again, they had probable cause on that prong.
I think we got it.
Thank you, Your Honors.
All right, thank you both. The case is submitted. Okay, our second case on for today is Commonwealth versus Barbosa, 24P179.
Good morning, Your Honors. My name is Attorney Carl Suchecki. I represent Mr. Barbosa in this matter. On the review of the record here, Mr. Barbosa did not get a fair trial. And the centerpiece of the Commonwealth's case was a conversation that was set up by the complainant and her mother, surreptitiously putting her mother on as a third party in a conversation.
How do we know it's surreptitious from the record?
Both mother, the complainant, and the mother who listened in on the phone call testified to the fact that she was a third party, that her job was to be quiet. The mother testified that she was quiet, and the daughter testified that her job was to be quiet. The Commonwealth introduced records that proved that this call took place.
How do we, again, I go back to surreptitious. How do we know from the record that the defendant didn't know that somebody else was on the phone?
Well,
there's no affidavit from the defendant. He didn't testify about it. There was no motion for new trial. So as far as we know, he knew that somebody was on that call.
Well, first and foremost, if you read the testimony, she's asking questions, and he responds to the questions like, if you say this, there'll be a certain result. And she says, well, he actually admits that he's actually telling her if she actually reveals this to her mother, then this will happen. So the evidence is in the phone call that he doesn't know about it. And like I said, the mother and the daughter both admit the fact that they did this unbeknownst to him. And then the daughter calls, with the phone records, it proves that the daughter calls the mother back.
But what's your argument that comes from this? I mean, the response that I read your brief, and I was like, whoa, this sounds like a real issue. And having dealt with this statute a few times recently, and then the Commonwealth responds, yeah, except there are cases that specifically hold that you don't suppress the evidence if it's privately obtained.
That's not true, Your Honor. You actually read the statute. The statute is not...
I'm not talking about the statute, because I might agree with you on that point.
Well, it's a statutory violation, so I mean, it's unambiguous.
There's a Supreme Judicial Court case that says we know what the statute says, but we're not going to suppress it if it's purely privately intercepted. That's Santoro. What do you say to that? There's no reply brief. You don't address it.
Your Honor,
now you have to tell us how do we distinguish a Supreme Judicial Court case that appears to be directly on point that says we don't suppress it if it's privately obtained.
And Barbosa,
if you actually look at the most recent Supreme Court case on the SJC case, Due, which talks about the privacy of...
I'm well aware of Due.
I'm sorry?
That's government action.
Yeah,
the SJC one. I'm sorry?
It's government action.
I'm sorry.
That was government action in Due. That was the government did that, not a private individual.
But the language in the decision specifies the privacy interest. The Commonwealth tries to say in their brief that it's a state action.
Are you arguing now that Due sub silentio overruled Santoro and I guess Barbosa?
I don't believe that that's what says what it says. I think that, Your Honor, that the statute is unambiguous.
Hold on. What do you believe doesn't say what it says? Santoro?
Well, frame the question clearer for me, because the way this case played out was it's a statutory violation for the two women to do this.
Let's assume that's right. Let's assume that's right. That's easy.
Right.
Assume that the two people involved committed a violation of the Wiretap Act.
Right.
Now, what do we do with the case where there was also a violation of the Wiretap Act by private individuals and the Supreme Judicial Court refused to suppress the evidence?
Are you talking about the phone call with the extension, the telephone call with
That's
View?
Barbosa. You
And
can
then
address
there's
that
View.
second. I'm talking about Santoro.
In Santoro, the SJC specifically says, where law enforcement is not involved, there is no deterrent purposes in suppressing the intercepted conversations. I'm not sure how we get around that in this case. Law enforcement was not involved in this conversation, this intercepted conversation. Mother is intercepting it, and the SJC is saying there's no deterrent purpose. There's no reason for the exclusionary rule.
This is a statutory issue. It's not an exclusionary rule. This isn't a rule of evidence, Your Honor.
In Santoro, they're talking about the wiretap statute.
But in Due, they literally just had this
Let's
taste.
leave aside Due for the reason that Judge Massing just identified. You agree with us, Due is not a private individual, right? Due is the government.
Right. But at the
okay?
same time...
Hold on. I'm going to read to you from Santoro. Section 99 does not, however, require the suppression of all communications intercepted in violation of its provisions. The legislature has left it to the courts to decide whether unlawfully intercepted communications must be suppressed. What do we do with that language? They then go on to hold, we're not going to suppress this because it was privately intercepted.
Well, it may be privately intercepted, it's still unlawful. So what you have is you have a judge who has a case before it that it's unlawful. This is tainted. This is incompetent evidence. It should not be before the court. So the judge should have seen that at the outset.
Well, no. It's not incompetent evidence. It was unlawfully obtained.
Well, it's warrantless, it's unlawful, but the Commonwealth knew, or should have known, that the evidence that they were presenting to the court was unlawfully obtained. It's unequivocal, it's unambiguous.
Okay.
That statute is very clear.
All right. So we're with you that far. What follows from that when the Commonwealth also should have known Santoro and Barbosa, which say, we're not going to suppress it?
I disagree with that finding. I think it should be suppressed based on the fact that it's a statutory violation. There's this
Okay, you know what,
testimony-
I think we've heard,
Right.
we're going round and round and round.
Right.
And-
So regardless of what you have three actors here, whether you pick the defense counsel for not filing a motion to suppress, or the prosecutor for presenting a case that's incompetent because that's illegally obtained evidence, or the judge who should know on its face that it's incompetent evidence. It's unlawful. There's no warrant. It's unlawful. There's exceptions in the statute, but it's only as to...
And the judge should ignore Santoro because if the statute says something and the SJC can't overrule a statute.
I don't think that, I think if you actually go through due, they're still talking about the privacy interests. The Commonwealth in their brief saying that, well, it's going to somehow suppress the Commonwealth or the government's
Let me ask you this. The unlawful part was the mother listening in. Suppose we suppressed the mother's discussion of the mother testifies to the conversation. Suppose we would suppress that. Doesn't the daughter still get to testify about her conversation? That part.
I would think if there was some way to separate the two, perhaps, because in that instance...
There is. Say that the daughter can testify and the mother can't.
Right, but there's no way, based on the way the testimony played out at trial, to separate the two. I mean, it's all part and parcel of their case was this phone call. It's everywhere in the case.
Well, their case was that this confirmed what the complainant testified to. It corroborated.
Right.
The case itself was the complainant testifying to the acts the defendant committed on her. This corroborated it. So
Right.
what Justice Massing is saying, take the mother out of it, you still have a telephone call years after the incident where the defendant admits, yeah, I did that, please don't tell anyone.
Well, if in a new trial that he deserves, perhaps that's the way it will play out. But the way it played out at trial, it's too intermeshed. And they're literally, the two participants are admitting to violating the wiretap statute. They're both saying that, yeah, that's what we did, and it's a violation.
So
statutorily,
let's go one step further. Let's assume maybe that, without deciding, that maybe Santoro can be laid aside. What about Barbosa, which talks about the fact that this is sort of a familial kind of situation? We have a familial situation here. So
but it's
that doesn't change anything in your mind?
I don't think it changes anything. I think that there's...
So we need to ignore Barbosa then?
It's not an expectation of privacy situation. It's a statutory...
Can you answer my question? Do we need to ignore Barbosa, which is a decision of this court? Ordinarily, we would not ignore a decision of this court that precedes
I would follow the SJC line of reasoning and due, which says that there's a privacy expectation in privacy. This is a privacy interest that they've literally unambiguously says that you cannot use this information. You can't talk about the actual phone call. You can't talk about the contents of the phone call. Someone who's monitoring the phone call can't testify as to what they heard on the phone call. Everything and anything about that phone call, the way it was presented at trial, should be suppressed. It should not have come across. So if we're talking ineffective assistance of counsel...
What's the purpose of the exclusionary rule?
This is not the issue, though, Your Honor. It's not an evidentiary issue. It is solely a statutory... The Commonwealth...
Well, humor me. What is the purpose of the exclusionary rule?
I wouldn't know the answer off the top of my head, Your Honor.
Isn't it to deter police misconduct?
I'm sorry?
To deter police misconduct?
Right.
Okay, and there's none here, right?
Not that I know of, Your Honor.
Okay.
But that's irrelevant.
Because it's
what we're dealing-
unlawful.
It's irrelevant because what you have unambiguously, as per due, if you look at due, it's a privacy interest. It has nothing to do with the police. It has a privacy expectation of every citizen of the Commonwealth. That you can, it's the way for example, in due, they say that the audio-video footage was an unlawful, warrantless. It would undermine the deterrent effect the legislature intended to safeguard the privacy of the Commonwealth's residents. It also stated the strong remedy for violations of the Wiretap Act is suppression because of the uncontrolled and unrestricted use of modern electronic surveillance devices pose to grave dangers to the privacy of all the citizens of the Commonwealth. This is a privacy interest. They violated the privacy interest. Both of these parties admitted to violating the statute in trial. This evidence should not have come into trial. And then, furthermore, even later, the testimony of the mother recounting it, it's one thing to have the daughter testify to contents if it was just her, but the mother testified exactly the same way the mother did. So we have issues with first complaint, where they have a first complaint witness, they've identified the first complaint witness, but the daughter gets to say the...
So let's talk about first complaint, okay? So in what way was hearsay evidence introduced with respect to the what hearsay statements came in this context that you think should not have? Right? I mean, that's what the first complaint doctrine says. You get one person to talk about what the victim said. That's it. That's the only hearsay we're going to let in, and that's it. So what hearsay statements came in that you're worried about?
Everything the mother said, repeating everything the daughter said. It's one thing to have...
About what?
I read the testimony this morning, and I mean, I understand your point here, but I have to say the testimony itself was not that, it wasn't specific. In other
In your
words,
brief, did you tell Detective Brooks about the phone call? Yes. Did you tell him the content? Yes. That's it.
But tell me the contents. So what is the contents of the phone calls? What the mother just testified to. So it's totem pole first complaint.
But the content didn't come in at that point, right?
No, but the testimony of the both of the witnesses regarding the complaint that she made to her father is a violation. You can't have multiple cases, and there's also nuance other times during the trial that there was first complaint violations. But
so look, here, let's talk about evidence, all right? The evidence is, here's the daughter. Question, what happened in February 2021? Answer, I spoke to my mother, and then I told my mother what Luis Barbosa did to me. Okay? That's what you're complaining about, right?
That's
that one
them, yeah.
phrase.
Yeah.
It's non-responsive to the question. The question asked by the prosecution was perfectly fine. There's no objection. There's no motion to strike.
Right.
Okay? So what's the judge supposed to do in that circumstance? Let's say that's a violation, even though, frankly, I told my mother what Luis Barbosa did to me is not very substantive.
It might be a bit on the line, but there's more than that in this
Not from
case.
the daughter that I found. That's why I asked you the question. What specifically are you referring to? Now,
Well, ultimately, the biggest and giantest piece of evidence that was admitted in this trial was the unlawful, warrantless evidence of the...
But that's not first complaint. It
is if it's repetitive, if they're saying the same thing.
Counsel, if we put aside the violation, let's assume for a second, hypothetically, the defendant knew mom was on the phone, and it's a three-way call, and the victim said, or the complainant says to the defendant, tell my mom what you did to me back a few years ago, and he says it. That's not hearsay. That's an admission by a party opponent.
Right.
So that doesn't run afoul of the first complaint rule.
Right.
So what we're talking about is first complaint. That telephone call has nothing to do with first complaint. Put aside your alleged argument about the violation. What you argued is the violation of first complaint is what Justice Englander just read.
That's just one of many.
I think also a segment about where the mom or the daughter talks about him coming into the bed and sleeping with her.
Right.
well, there's
Which
another...
was not an assault, by the way, so I'm not sure why that's a violation of the first complaint. He just comes in and goes to bed. So why is that a violation?
Well, there are some more stronger than others, examples of the first complaint violations in the brief, but I'm saying right out of time, but the most important thing for you to remember, and look at due, because the language is unequivocal, and I want to leave you with the last thing they said on due, was that the legislature intended to tailor its statutory remedy of suppression to the evil of the unauthorized interceptions by ensuring that no evidence of the existence of the interception comes to the attention of the fact finder. And they even say the contents could equal even live testimony from memory of a party to a conversation. Mr. Barbosa's rights were violated here. It was an unlawful, surreptitious interception of his communication, and it should not have been allowed, and therefore he got an unfair trial. And also for the reasons of first complaint that are written in the brief, I address them in my brief. Thank you, Your Honor.
Thank you. We have from the Commonwealth.
May it please the Court. Assistant District Attorney Krista Elliott from Middlesex on behalf of the Commonwealth. The Massachusetts Wiretap statute gives a defendant standing to bring a motion to suppress if an unlawful interception has occurred under Section 99P. It does not require automatic suppression of the unlawful interception, and courts assess, as the panel has already discussed, whether or not suppression is warranted based on traditional exclusionary rule principles.
Is it your position? So I understand your argument because that's what Santoro says.
Yes.
So you have to argue it that way. Is it your position that exclusionary rule never applies to privately obtained?
No.
Okay, so sometimes it does, certainly if the government was involved in some way helping it along, right?
Correct.
Okay, so what do we do with the argument? We just ignore this because there was no objection, there was no concern raised at trial, we just ignore what the other side says? We say, well, Santoro says that you don't suppress it if it's privately done, and therefore there's been a violation, but ho-hum.
Well, so I think that there's a second piece at play in addition to Santoro, and I think that that's actually the statutory language itself, because Section 99P does not require suppression even under the language of the statute. It specifically says that a defendant may move to suppress in one of the enumerated categories. And so no matter what, you're talking about a permissive motion to suppress, even under the statute. So it's not...
So let me see what follows from that, because I'm staring at that language myself, okay? So what follows from that, you would say, is that it was not error for the judge to say nothing when this evidence that was illegally obtained came in, because it's a may move to suppress.
Correct.
Right?
There is no requirement for any party to bring this to the court's attention.
Do you read P to say, as the Supreme Judicial Court had read it, if you move to suppress, the court can still do whatever it wants with respect to whether it should be suppressed?
Yes, because there
Isn't that exactly what Due says is wrong?
So Due has some language in it that I think is a little bit misleading in terms of how it is presented. Specifically, I do understand there are portions of Due where it does seem to say that it is suppression is required. There's one location.
I can't read Due any other way than saying that suppression is required when it applies it to the video evidence.
When it applies it to the video evidence.
Yeah.
So, but it's specifically talking about where there is
Video
police
evidence is not a
misconduct.
communication, okay, in Due. The video evidence is not a communication, so the only reason that it's suppressed in Due is because the court is reading that language, when it's applied in the government context at least, as required suppression.
And I think that seems to be more in line, that I would have less of an issue, I have less of an issue with that interpretation in terms of government conduct. But the Due is very clearly a case that deals explicitly and exclusively with government conduct. It is entirely outside of the realm of private conduct.
Except for the fact that it's construing subsection P, which is the section that talks about what the remedy is if there's a violation of the act.
But I think that it is construing P in the context of the exclusionary rule, the purpose of which is to deter government and police misconduct. And so it is looking at it through that framing. There is one of the locations that in Due, there's a section at one of the first portions that it talks about suppression. It makes it sound as though suppression is required, and then it cites to another case, and I apologize for not having that off the top of my head, for the proposition that exclusion is required. But when you actually look at that case, it's citing, the quote from that case is generally exclusion is required for a violation. And so I think that's important.
You think maybe with Santoro in mind?
I think perhaps that it had Santoro in mind. And certain other cases as well. I mean, we also do have Barbosa, we have View, and these are cases.
It's an earlier case too, yeah. Was the earlier?
What if we take the conduct of the Commonwealth, the prosecutor, of introducing evidence of an unlawful communication as government conduct? Would that square within the statute as opposed to the exclusionary rule? I mean, I have a problem with, let's assume we buy the defense argument that this was a clear violation of the statute. I have a problem when there's a clear violation of the statute, the prosecutor goes, so what? I'm going to introduce it into evidence anyway.
But I think that it is important to differentiate within the statute the sections that deal with suppression versus the sections that deal with liability. Because
So he can sue.
Yeah, of course. If there were a violation,
Doesn't do him much good while he's sitting in jail.
But the purpose of the statute is not to protect defendants who have inflicted incredible harm on victims. And that is what suppressing...
I don't understand that argument at all. I mean, neither is the purpose of the Fourth Amendment. I mean, we're talking about whether or not this was obtained in violation of an act. The fact that there's some victim out there is not what we're looking at, is it? Ever in that context.
So I think that, again, it's important to...
I mean, there's actually a piece of your brief where you seem to argue that, of course, this is okay because we're going to get a defendant here who's committed a violation of the law. And that's just so inconsistent with any concept of suppression related to a violation of privacy.
So I don't think that is not what I intended
Tell me what
to...
Judge D'Angelo's asking.
Sure, and I don't think that's what I intended to communicate with through my brief. That was more intended to be an extension of, the suppression is intended to prevent government misconduct. We are preventing no government misconduct here. By suppressing something that is devoid of government misconduct, we are creating a situation where a defendant is then able to hide behind their misdeeds based on a statute that does not actually require suppression. It is a permissive statutory section. It is not mandatory. And to find that it is mandatory when the language of the statute doesn't even support that, and where our case law is incredibly clear that that is not required where there is private conduct, would put victims of crimes in incredibly disfavorable positions and allow defendants to act in many circumstances where they have...
That's what you said in your brief. That's where you lost me, right there. I mean, the question is, what's the remedy for the violation of the statute? That's the question for lawyers and for the court, right? What's the remedy for the violation of the statute? You say, Santoro says there is no remedy in this context in terms of suppression of evidence.
It says that there is no remedy and that a motion to suppress should be denied where there is no government conduct. A defendant would still have standing to bring that motion to explore.
What does that mean? They have I mean, you're basically saying they have standing, but it's automatically going to be denied. So what? If it's a private individual, you're saying they have standing, but it's automatically going to be denied. So the statute gives power to nothing.
I don't think that that's entirely accurate. I think that it is, a defendant would have standing once they can establish that there has been a wiretap violation. They can then explore through a motion to suppress whether or not there has been, what the violation was, whether there has not been government conduct. It would be an evidentiary motion in the same way that a regular motion to suppress would occur. And then a judge would have the opportunity to make a determination. Again, we go back to the fact that in order to, that the suppression under the wiretap statute is much broader than our Fourth Amendment jurisprudence. It covers a much broader array of activity. And so it does make sense that there would be certain circumstances where it would be absolutely futile to bring this type of motion, where it would essentially be, there would be no point in furthering any exclusionary rule by suppressing something. And so yes, there would be circumstances where it would be futile to bring such a motion, which is probably why we don't see more of these cases, because the case law is relatively clear. It's old, and I think that it would be a great thing to have some newer case law that reiterates Santoro and reiterates Barbosa and View. But it is clear, and so that is why we don't see more of these motions.
What about, and I guess this is a straight evidentiary issue, that a police officer was allowed to testify about the three-way conversation? Why was that admissible?
So the police actually, I think the interesting piece here is that actually it was the defendant that first put testimony before the court about the fact that, before the jury, that there was in fact a conversation with the police. He put it before the court in relation to a different officer and essentially had on cross, had the victim testify that she had had extensive conversations about that three-way call. And so that really opened the door for the Commonwealth to, briefly mention it. Again, the mention that the Commonwealth elicits is incredibly brief. And it is, I think, frankly, less than what the defendant had already put before the jury. In terms of the, kind of moving on to,
Let me make sure I understand that, because I came in thinking, boy, there's an awful lot of evidence here about other complaints. There are the statements that we were talking about with your opponent, although I think if you look at those, the questions are not objectionable. There is no objection. There's volunteered information. There's no motion to strike. But the mother puts in, the daughter told me that he raped me, right? That's second complaint, right? I think you'd agree with that. The mother's testimony.
that one is certainly quite close to the line.
Okay, and then they put in the evidence, then they go and they start talking, the prosecutor, starts talking about what was said to the police and asks a specific question. Did you tell them the contents of the conversation? Yes, which is third complaint, right? But what you're saying about that is that was invited by cross-examination that occurred earlier at trial.
Correct.
Okay.
That's correct. Yes.
Can I go back to a question? I think Justice Englander asked it to your opposing counsel. It's true that the mother, about what she talked about with the daughter, is this one sentence, I won't say a throwaway, one sentence that says, she told me what happened. I mean, without getting into the details, isn't that testifying to the details? Because the jury just heard everything that the complainant testified to, and the mother, against the first complaint rule, is corroborating that. So do we need the details for there to be a violation, or isn't that just enough? I mean, it will be one thing is said, I talked to my daughter, period. Well, we don't know what she talked to him about. But when she says, I talked to her about what happened, that basically invites the jury to say, oh, the daughter told her everything that happened.
Yes, I think that I do think that this may come close to an additional complaint, again, truncated, limited as it may be. But I do think that it comes close but may not actually quite be there, particularly where, I mean, you have the defense's entire strategy is to kind of say that the victim is making these things up, that to undercut her credibility. And we have Commonwealth v. Lawton. That's out of this court from 2012. It's 82, Mass Appellate Court 528. And there is
Counsel, if defense counsel tries to get in other complaints for a strategic purpose, maybe on redirect, the floodgates are opened. I would agree with you. And that's the peril that defense counsel takes when they introduce other complaints for impeachment purposes. But this was done, I believe, on the direct by the Commonwealth.
That is correct. This was on direct by the Commonwealth. I certainly don't contest that. You know, I do think that there is some question as to whether or not this is a complaint, because the purpose, there are other purposes aside from putting in a complaint here that for which this testimony would have been admissible.
Talking about testimony of the mother where she says, my daughter said that he raped me when I was 14. What are the other purposes that would go in for that?
So for that, honestly, I think that it kind of just combines with the victim's testimony, because as Your Honors have pointed out, the jury is aware of what the victim has testified would have happened. The reasonable inference would have been that if the victim did say, I told my mother what had happened, that is probably what the jury would have inferred she said. And so that is confirmatory of what the victim had already said. So I don't think that it piles anything on.
That wasn't admissible either, was it?
That I told my mother.
The Commonwealth made the first complaint choice Wayne because grandmother was out of the picture.
Yep.
No question about that. I think it's Wayne. I hope I got it right. They choose Wayne. The daughter is not, the complainant's not allowed to testify on direct examination. I told Wayne, blah, 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 and then a little later say, I also told my mother. That's a violation of the first complaint. Whether it's one sentence or not, you chose one person, that's the person.
And I do think that this does come in really for the purpose of showing the overall kind of area that this gets us to is it really is just undercutting the defendant's strategy, which is to undercut the victim's credibility. It highlights the fact that the victim...
That's exactly why, when they're challenging the credibility of the victim, that's exactly why King was written. You get one. You don't get three, which you have here. You have three. you have Wayne, you have the statement by the mother that she told me that he had raped
and
me,
the
and you
victim's
have you have the statement that they then went to the police and told the police.
So I think,
And you know, and it's being done for exactly the reason that King is concerned, which is to bolster the credibility of the complaining witness.
but going back to the police, I again, that is a statement that was really already before the jury because the defendant put it there. And so I don't think that that particular statement is actually in the first complaint realm at this point. In terms of the statements of the victim and her mother in February 2021, even if this court does find that this is additional complaint evidence, again, as we've noted, limited as it is, there simply is no substantial risk of miscarriage of justice. There was no objection to any of this. And we have both Roby, that's 462 Mass 398, that's from 2012, and Starkweather, 79 Mass Appellate Courts at 791 from 2011. Roby talks about there's no substantial risk where cumulative first complaint testimony was brief, and Starkweather talks about the fact that there is no substantial risk given the level of detail in a victim's other properly admitted testimony and that of other witnesses when there has been a violation of the first complaint of the first complaint doctrine. There is no substantial risk. I do see that I am out of time. If there are no further questions, I would rest on my brief.
Okay. Thank you both. The case is submitted. So the third case on for today, we're gonna hear one more case, and then after this case, we'll take a 15-minute break. So for 4, 5, and 6, you'll be on, and number 4, you'll be on about 45 minutes. So the third case is 24P403 Commonwealth versus Urban.
May it please the Court, I am Russell Redgate. I represent the defendant, CODY Urban. Just as trial counsel did at trial, almost the entire focus was on self-defense, and I think that probably should be the main focus here. I don't want to waive any other arguments other than the one I did by letter to the Court, but I think the question of self-defense is really what we have a lot to talk about. And I think that the Commonwealth has overvalued its hand as to the 5 ways it can disprove a legitimate right to self-defense by deadly force. The first 2 of them have to do with the defendant's belief or the belief that a reasonable person would have had. And the Commonwealth starts by saying that it's just a punch. Why would he be afraid that the decedent was going to kill him? But of course, the proper instruction is a reasonable belief that he's facing imminent death or serious bodily harm. That punch was a pretty effective punch. You'll notice one of the cases the Commonwealth cited in its brief, I think it was Commonwealth versus Ramos, but the point is that in that case, an instruction on the use of deadly force in self-defense was denied. And one of the reasons the court leaned on, even though the decedent had been hitting the defendant with his fists, the court twice mentioned that he used the fleshy part of his hand. He seemed to be pounding on the defendant. And in another place, the reference is to there's no evidence that he used his knuckles. This punch, on the other hand, you can see in the video, it was very effective. It was right on the button, right in the face, knocked the defendant backwards. So,
can I just ask you a legal question about
Sure.
this? So there was a self-defense instruction, right?
Oh, yes.
Yeah, so, and you're challenging as a sufficiency of the evidence.
Yes.
So, do we have to find that the evidence was sufficient on every single theory that the Commonwealth can use to negate it, or just one?
No, it seems the instruction was correct.
No, but I mean in terms of the evidence. So if we were to agree with you on that, but disagree about excessive force in self-defense, would there still be sufficient evidence?
Yes, if the Commonwealth has proven beyond a reasonable doubt any one of the 5 factors that the judge instructed on and that the Commonwealth argued, and the Commonwealth did a good job of, at least devoted a lot of time to it. I just think that in each case, it overvalued the strength of its evidence to say that...
I'm struggling why there are 5, because I'm reading the Commonwealth's brief on page 24, and I see 3. And it did not have reasonable ground to believe, and did not believe he was in imminent danger of death or serious bodily harm. You've touched on that one already. Defendant did not avail himself of all proper and reasonable means in the circumstances to avoid physical combat. The defendant used more force than was reasonably necessary. What are the other 2?
Well, the first 2 were combined. There's one, sometimes it's independent, that the defendant didn't actually believe he was in danger.
Isn't Justice Englander's question one of them would be retreat?
Yes, definitely.
So what's the other one? There's 5.
Yes.
No, defendant did not avail himself of all proper reasonable means in the circumstances to avoid physical contact. Is that different than retreat? It is?
I think it is.
Sounds like retreat to me.
I do think those are the same, but I do think that the belief of the defendant is in 2 parts, whether he actually believed or whether a reasonable person would believe.
All right. I'll buy that one.
So that's
now I got 4. Where's the 5th?
Give me a second now. So that's 2. Then there's the duty to retreat or avoid combat, and then there's the excessive force. And the last one, if you'll just give me a second.
Because at the end of this, then Judge Massing's question comes to the fore, which is if under the Lattimore standard, a reasonable jury could have found any of those, then the verdict stands, correct?
That's correct, but the standard is beyond a reasonable doubt. So it's the same as...
The Lattimore standard's done in the context of a criminal trial, right?
Well, it doesn't govern every aspect, but yes.
And so the Lattimore standard applies to the beyond a reasonable doubt standard.
Yes, if a reasonable, rational jury could have found one of those 5 factors had been proven beyond a reasonable doubt, that would undercut the defendant's right to use deadly force in self-defense. And as I said, I think the Commonwealth has overestimated the value of its case in every respect. If you look at the cases it cited on means of escape, and compare to what we see in the video here, where the defendant is knocked back on his heels, and that's not sufficient because his assailant pursues him. Defendant doesn't retaliate in any way at first, and then they're both locked together. It's a swirling battle. It's not easy to see exactly what's happening, but it's pretty clear that the defendant...
But we don't see it, don't you think? I mean, having gone through it frame by frame a couple times, we don't... The victim is stabbed 4 times. We don't see any action by a hand 4 times. So there's this point where the view cuts from one to the other, and it appears that that's when that happened, right?
It's the best guess. I mean, it's not, we don't see it. That's a fact. I don't see it. You haven't seen it. And yet, the man had 4 stab wounds. He didn't seem to have them before this struggle broke out. It doesn't look like, that's the argument I withdrew, by the way, because a portion of video turned up after I'd filed the brief. Defense counsel, trial counsel, explained to me how that could have happened. I was astonished, but it did, and the Commonwealth provided that. After I saw it, it appeared to me that no one else could have done the stabbing. So I withdrew that argument.
Understood and appreciated. But now we've got this problem, which is you say no reasonable jury could find any one of those 5. So what about that it's unreasonable force? I mean, accepting your characterization that clearly your client was not the first aggressor in terms of physical aggression, and that the victim continued to pursue your client after punching him in the face, but it was a punch, and they're locked in some sort of embrace, at which point your client stabs him 4 times with a knife. Can't a jury find that that's not a reasonable force in response to the situation?
I don't think so. I look at the Commonwealth's argument on that point very carefully, and I think the Commonwealth makes unrealistic assumptions about how a knife could have been wielded in a way so as not to inflict deadly force. It could have slashed his arm. He could have done this and that. If you look at that video, both men are grabbing at each other's arms. And I have no idea whether the defendant knew whether any of his blows were striking home or doing any damage. The fact is that after presumably all 4 of these wounds had been inflicted, the decedent is still grabbing at the defendant. He wasn't free to get away. He didn't know that whatever he'd done with his knife had saved him. So, no, I don't think any rational jury could have found beyond a reasonable doubt that he used more force than necessary. I don't think he had any reason to stop. The decedent hadn't let go of him, was still locked in combat with him, a combat that the defendant never sought, and doesn't seem to have thrown any punches.
You know, accepting all of those arguments, counsel, the difficulty I'm having is that, and it's like going through my head, this is why we have juries. Usually, in the old days, this would all be described by witnesses but here we have a video. And the jurors, they're going to apply community standards and they're going to decide whether what happened was reasonable or not in light of that, aren't they? How do we take that out of the jurors' hands, I guess is what's on my mind.
Same way a trial judge would, by saying, could any rational jury have drawn this conclusion? So I agree with the Commonwealth. Ordinarily, these things are in the hands of the jury, but that's after first a trial judge says, your motion for required finding is denied. I find some rational jury could. And although it's rare, occasionally the appeals courts disagree with trial court and say, no rational jury could find that. And yet, this jury did. So it's perplexing, but it happens. And that's my contention here.
Where that?
Yes.
But it is a classic jury question. Whether this was reasonable, whether this behavior under this set of circumstances, which is on video for the most part,
I agree that it's almost entirely on the video. There isn't anything else. And I think as I withdrew the question of whether anybody else could have stabbed him, but I didn't withdraw the issue of whether it was the defendant who's the man in the video. And I think there's some significant evidence on that point. I mean, the lack of blood evidence anywhere, the lack of a knife on the ground or in the car, or any blood in the car or on defendant's clothing, which they seized.
Although, isn't there pretty good surveillance of the defendant's car the stabber, whoever that stabber is, gets into a car, drives away, and they've got the license plate and they follow it and it's rented to your client?
No, Your Honor, that's close, but it's not quite right. The car that they can tie the defendant to, the state police officer could only say that it is the same or similar to the car that the man locked in combat with the decedent got into and drove away. And it does. It looks similar to me, too. And I conceded that the circumstantial evidence on that point would have carried the day on a civil standard.
I thought that from the record that they could actually they got the license plate from the video.
They got it from an earlier video of the defendant in daylight. They couldn't get any license at the time of the struggle. And all the state trooper could say was the cars are similar or the same. And that portion of his testimony is reproduced in the appendix and quoted in my brief. But they never could say that that was the same car. And I have to agree, it is a similar car.
Can we use the fact that the jury found manslaughter as something that they did consider the self-defense and that it was perhaps excessive use of self-harm?
It's very plausible, but you can't really know that because provocation could easily have been found or sudden combat to mitigate murder to manslaughter, and we don't know. We didn't have a special verdict on that point.
But that's an interesting question. So if we agreed with you that it was, I guess if we agree with you it's self-defense, that takes care of the manslaughter as well, right? Okay.
If it was legitimate self-defense with deadly force, yeah, that would
okay, sorry.
That would settle the matter.
As opposed to imperfect self-defense, which would potentially reduce the verdict to manslaughter from second degree. Maybe that's a colloquial
If it was a
term that we
mitigating
used to
factor,
use.
provocation or something, but excessive force in self-defense, no, it would leave manslaughter standing. And by the way, the one point that I didn't mention, I think it might have had to do with that fifth way. The defendant clearly was not the first one to use force, but the prosecutor argued that he was the first and the only one to use deadly force. But he never mentioned what the judge properly did. It's not just that. You've got to prove that the defendant was not the first to use deadly force or to threaten deadly force. And that is a big mystery. We don't have any evidence on that point. There's an interesting exchange in chambers when...
Did the judge give the right instruction?
His instruction was good, yeah. He said absolutely, the first to use or threaten deadly force, but the prosecutor didn't. In chambers, when they had a discussion on that point, there was a reference to the decedent's girlfriend, a Miss Turner, who testified but said she never saw any of the fight. She also said she didn't hear any of the exchange. Now, there's an open car window. She's sitting in the car, and they're arguing pretty close by. She says she didn't hear anything once her man got out of the car. In chambers, defense counsel is skeptical of that. He doesn't believe that she didn't hear anything. And the judge stands up for the witness saying, well, no, she would have reason to testify correctly. And defense counsel says, except if all the evidence, all the threats were coming from her man. And that's certainly a valid possibility. I don't see how the prosecutor disclosed that. He threw a hard punch, and he wasn't satisfied with that. It brings to mind a common thing in breaking and entering intent to commit a felony where the crime is theft, and the thief only gets away with $50. We say, well, we presume that he wasn't going to limit himself to that. And this assailant...
Counsel, what's the point? So, okay.
It's that this assailant was not satisfied with landing a hard blow in the nose. He wanted more. So the defendant
okay, but there's no evidence as to what he said. You're saying maybe there were threats that preceded the punch, but there's no evidence on that. So what do we do with that?
It's slender, but I cited it and I quoted it. When Miss Turner was being cross-examined, she, by the way, grabbed a knife and got out of the car. And defense counsel asked her what made her go for the knife. And she says it was a gesture her man made that made her reach down and grab her knife. If he wanted her to join in with a knife, or that's what she thought, is it reasonable to think he made some sort of gesture rather than saying something which the defendant may well have heard? I think he had ample reason to be fearful that more was going to happen to him that would constitute serious injury. And the Commonwealth kept on that he didn't have a broken nose, he didn't have this, and he didn't have that. He doesn't have to have those things. He has to have a reasonable apprehension that he's about to receive a serious injury. And I think he had plenty of reason to fear that.
Okay.
All right. Thank you. We'll hear from the Commonwealth.
Good morning, and may it please the court. My name is Melissa Johnson. I'm an assistant district attorney in Plymouth County here on behalf of the Commonwealth, addressing the required finding argument. And I was listening to my brother's presentation, and to me it just felt like a closing argument and not a required finding argument. All of these points are interesting and well made, and the defense attorney made all of those arguments, but really what we're talking about is on this constellation of facts, taking all of the inferences in favor of the Commonwealth, are we going to really take this away from the jury? And they've heard all of the evidence, they've seen the video, they've heard and seen all of these witnesses, and they came back with a verdict that was supported by the evidence.
So on the issue of the car and the license plate, is he right about how that played out?
He is absolutely right. What happened was the day before, the defendant pulled his car into the gas station, and it was daylight, so the troopers were able to see on the surveillance video very clearly the license plate, in addition to the make and model of the car, and they were able to trace that back to the defendant, and they noted that the very next day, the defendant had visited the gas station multiple times during the day and into the evening, and it appeared to be the same car. So do we know specifically that it was the same license plate? No, it was at night, so they couldn't exactly see the license plate. But again, on a required finding standard, that inference is taken in front of the jury.
The question is whether the jury could find that, could rationally find that, not whether it was.
Absolutely, and we do have other evidence that places the defendant at the scene at exactly the same time, including DNA evidence of the Solo cup that he was holding at the time, CSLI evidence, cell phone evidence that placed him at the scene at that exact time and then fleeing the scene up to Haverhill and then to New Hampshire.
On a similar note, in your brief you say that the trooper was permitted to, that a trooper was permitted to identify the defendant in one of the videos. Was that also the day before or that morning or something? It wasn't, nobody identified him as the stabber, right?
No. No one identified him as the stabber, including Ms. Turner. I believe that the trooper was, that testimony, Trooper Kent, was just identifying him from, I believe, the day before because it was just clearer to see because that surveillance was in daylight and not at night. But after that, because the defense really wasn't identity, it was unobjected to because I believe that the sentiment at that point was it was the defendant who was at the scene, and the question really was he acting in self-defense? Either did he have the right to self-defense and did he exercise it disproportionately, or if he didn't have the right to self-defense, and we're talking about a murder charge here, whether there was reasonable provocation or sudden combat. So that's where I believe that we got to the manslaughter verdict here.
Did it go to the jury on first-degree murder?
It did, and our theory was extreme atrocity and cruelty because in this case, there were 4 stab wounds. 3 of them penetrated this victim's body 5 to 7 centimeters. So this was not just a slashing here in self-defense. He had plunged the knife 3 times into the abdomen, into the chest twice, and severing his aorta and piercing his heart. And that's really where the strength of the evidence was that excessive force in self-defense after the victim, had punched the defendant.
After a general question, I guess. After a 1 stab wound, if the victim is still fighting or grappling, is there still a duty to retreat after 1 stab wound or 2 stab wounds or 3 stab wounds?
Your Honor, it is so fact determinative. I do believe something like that would really go to the jury still.
How about in this case where we see the video, I don't, there's no evidence, we don't know how hard the victim was still fighting after receiving 1, 2, 3, but it does appear as if the victim is still doing something. Again, I can't figure out how much, but so is there still a duty to retreat there?
It is, it's tough to see here. This happened so quickly. He was stabbed continuously 4 times in a row, and it's interesting because the victim was still able to walk away and talk to his girlfriend and have her take him to the hospital. I do think that we have better arguments than that, to be completely candid with you. But I still
Are there any, and that was my follow-up question, are there any of the arguments, I'll call them the factors of self-defense as opposed to the elements, that you don't think we should consider that the Commonwealth proved beyond a reasonable doubt?
I still think that it's something to be considered in a required finding, the retreat element. And it's something that actually, candidly, the jury, I think, returned with a question about. So I don't believe that that's our strongest. I do believe that we have an argument to be made as far as the provocation or his fear of being imminently put in death or serious bodily injury, given that it was a punch. But I think our best and our strongest is what I made in my brief is the excessive force argument, and that is what I devoted the most of the time for. But I do think on the other two, if you're talking about a required finding and you're talking about inferences taken in our favor, I still think that we would prevail in that sense, to be honest with you.
So let me try to flip the question slightly. The Commonwealth has the burden of disproving that he acted in reasonable self-defense.
Yes.
So what is the evidence that you would identify that the Commonwealth put in that satisfied their burden of proof beyond a reasonable doubt?
So our burden is to prove that he did not, and I'm focusing on excessive force just for the purposes of your question, is that he did not use his right of self-defense proportionally. And we would argue that in this case, there was a punch and just a punch, and yet he came back at him, and as I had said before, plunged the knife into him. 4 times, there were 4 stab wounds, but 3 times between 5 and 7 centimeters into his abdomen, into his chest twice, and then immediately ran to his car and fled to New Hampshire.
Counsel, can I push back a little bit?
Yep.
You say it's one punch. Certainly there was one punch. But then opposing counsel makes an argument that the victim then pursued the defendant. That's different than just a one-punch fight and they walk away and he comes in and stabs, which we've seen before.
Right.
What do you say about pursuing? Doesn't that ratchet up a level?
I don't see the pursuit in the video, to be honest with you. I don't see that. I see a very brief scuffle, and then they separate. So I don't see this pursuing.
No. He slugs him. Maybe
slugs
I don't
him.
see things very well, but he hits him in the face. The guy reels back, and the space between them is closed by the victim. The victim closes that space. Now, whether you want to call that pursuit, whatever you want to call it, the victim is the one who's still approaching that person, right?
Right, and he's still not presenting a weapon. He's still not offering deadly force for which the defendant can reply with 4 plunges into his body. And that's what our argument is.
He locks up.
I agree.
He reaches out, he locks up.
I agree. However, again, are we going to take this away from the jury, given the injuries to the victim? Are we really going to take this away from the jury with those injuries to this victim compared to what the defendant suffered, which is nothing?
Well,
I
could flip that on the head. You yourself may have prosecuted someone with a one-punch kill. So,
yes.
There's a one punch, it certainly sends the defendant reeling back, and then the victim, to echo, goes at him. I think a reasonable person finds he goes at him more. So that seems to me to be reasonable provocation.
And that should
That's
go...
just me, not necessarily a juror.
And every case is going to have this constellation of facts, and it should go to the jury to kind of parse that out. As I said, I think that my brother here made a very good closing argument, but that's not a required finding argument here. It was proper to let this go to the jury. They came back with a just verdict here, which I think the defendant in some ways can consider a win. So I think at that point, and perhaps a loss for us, who knows, but I think in that terms, I think the required finding standard was met in this case. I noticed that we did not get to the impeachment issue or to the closing argument issue. I'm happy to answer any questions.
I wanted you to answer about the argument that nothing contradicted. It was Turner's testimony that he didn't have a knife. Saying whether the victim had a knife or not would be a pretty relevant issue.
Well, when I first saw that, I agree. It kind of, the hairs on the back of my neck stood also, Your Honor. However, when I looked at the actual closing argument and I looked at the actual evidence and how that came in, I realized that it really it was no issue at all. Number one, as far as our closing argument and how that came up, that was a direct response to the defendant's closing argument, where he accused the victim of this kind of sustained violent assault on the defendant, which I think if you look at the video, I'm not really sure that that is true, but even if it was, the prosecutor was entitled to respond to that in kind, because we do have the burden of proof to show that this defendant was not in imminent fear of death or serious bodily injury. And number two, when I looked at, and also the way that the prosecutor framed it, he said, no weapon, as you can see from the video. So
That's the next sentence afterwards,
Yes.
right?
Well, it
He
was
says
part
there's
of the
nothing to
same
contradict
sentence.
it. Look at the video.
Yeah, it was part of the same sentence, so I think he was really trying to direct the jury's attention to the evidence that was in evidence, or the video that was in evidence. And the other thing is when I looked at how this came in, it was the defense attorney who had asked Ms. Turner, your man, he had a weapon, didn't he? And she said, no, he didn't. I had one. So the defendant was the one who elicited it. And so in that sense, we were, I think, even if nothing else, were entitled to comment on it in closing argument.
There was, correct me, something flashed in my head. There's no evidence at all that the defendant at the time of this battle knows that the girlfriend has a weapon.
I don't believe so, no. There wasn't any interaction between those two, so I would never go as far as say that.
Except for maybe the gesture.
I don't believe there was any evidence that he would have seen the gesture or she would have seen a gesture. I don't believe that was part of the equation, Your Honor. So if there are any further questions, I would rest on my brief.
No, thank you both.
Thank you.
Another interesting case today. We'll submit that. And we're going to take now a 15-minute recess. We'll be back at no later than 11:20 for case number 4, which is the DCF case. Thank you. So we're back on the record for 24P415, Department of Children and Families versus Father. Remind the parties that this is an impounded case, so no names we'll refer to people by their, describe them as opposed to name them. And so you're representing the father?
I do. Thank you, Your Honor. Roberta Driscoll-Weiss, may it please the court. I'm here today on behalf of the father. The primary issue I'd like to address today, if I could, is the issue of whether or not the juvenile court in Suffolk County had subject matter jurisdiction over this case. Because that determination is largely fact-specific, I would like to begin with setting out some of the facts as I understood them to be in my brief. In or around 2011, the mother in this case moved from Massachusetts to North Carolina with her family, and she resided in North Carolina until the fall of 2015, when, because she was pregnant, her mother sent her to Massachusetts to reside with her grandmother. This was apparently in an attempt to get some distance between her and my client. And that can be found at finding 54. Finding 55 notes that the grandmother, who resided in elderly housing at the time, was not an appropriate place for the mother to live. And so mother, 17 years old and pregnant, found herself homeless. She was able to secure shelter residence at a pregnant teen shelter. And she was there when the child was born in January of 2016. In March of 2016, the only 51A in this case was filed. And the allegations in that 51A were not that mother was abusive or neglectful, but rather that she was, and I'm quoting, undereducated in terms of being able to parent a child. DCF did not remove the child at that time, but they did open a clinical case for services. The following month, in April of 2016, mother learned that she was being terminated from the shelter, and she communicated with father to come from North Carolina, pick her up, take her back to North Carolina, which he did. And that is located in mother's testimony beginning at transcript 1030 and continuing at transcript 1207. Mother went to North Carolina with father, returned to Massachusetts sometime thereafter to retrieve her belongings from the shelter.
Where's the child at this point?
I apologize. When mother initially went to North Carolina with father, she brought the child with her. When she returned to Massachusetts to gather her belongings from the shelter, she brought the child with her again. So the child traveled to North Carolina and back to Massachusetts.
Where does it say she came back to get her belongings?
That's at transcript 1207. That was mother's testimony.
Does the judge make a finding to that effect?
She did not, Your Honor. Finding 74, however, notes that, and this is also noted in the department's brief, that when mother returned to Massachusetts, the department filed a care and protection petition because they were afraid that mother might, and this is a quote, flee the jurisdiction. Mother had told her worker she was moving to North Carolina because she'd been evicted from the shelter. So I believe there's no evidence of any intent to flee when she was very forthcoming with that information. Despite the fact that there was no 51A alleging abuse or neglect, the juvenile court at that point allowed the petition and opened the care and protection case that is an issue here.
And then the child was removed.
And the child was removed at that time.
And wasn't he removed on stipulation at that point?
I'm sorry, Your Honor,
I'm sorry.
It's okay.
Wasn't he removed on stipulation at that point?
I believe the temporary custody, so the child was removed prior to the care and protection being filed. The petition was filed ex parte, as typically happens in these cases. I believe the mother may have stipulated at the temporary custody hearing, father stipulated at the temporary custody hearing, but no question as to jurisdiction was raised at that time. And that's where the problem began, because it's my contention.
Can I ask you a follow-up to Justice Englander? Is a stipulation to temporary custody an affirmation that mother and father were giving jurisdiction to Massachusetts?
I don't believe so, Your Honor, because I don't believe there was any discussion of whether Massachusetts needed them to do so in order to attain jurisdiction, because under the...
You lost me right there. How can DCF take custody unless there's jurisdiction?
Because the child was in the Commonwealth. And under the Mass Child Custody Jurisdiction Act, which is 209B, the court at that point, regardless of where jurisdiction over the later proceedings would lie, the court could assume...
Is that for emergencies, 209B? So this is different, though. This is the parties, mother and father, stipulating we agree to give custody to the department temporarily. Isn't that a stipulation that, okay, Massachusetts, you're going to do what you're going to do, and we're agreeing with that?
I don't think...
Temporarily, at least.
I don't think so, because I don't think you can stipulate to something that you're not made aware of, and there's no evidence in the record at that point in time that jurisdiction was an issue. It was not until later in the proceedings that the trial judge, and there were a number of different trial judges, so I'll say trial judge number one, on November 7th of 2017, the first reference to whether or not the Suffolk County Juvenile Court had subject matter jurisdiction to continue to hear the case, not the emergency removal, but to continue to hear the case.
What was the reference that was made at that time?
I apologize, Your Honor.
That's my fault. I'm sorry. What was the reference that was made at that time?
So at that time, the court questioned mother's connections to Massachusetts. This is at transcript 245. And at that point,
And said exactly what?
I believe said, does mother reside in Massachusetts? Is this, can Massachusetts, I'm paraphrasing, but I think it was something to the effect of.
But I think it may matter, because, and Judge D'Angelo's raising an interesting question, and it's on my mind as well from almost the first sentence that you opened with. Okay, our law says subject matter jurisdiction can be raised at any time, but very close to the first sentence you opened with was, it depends on the facts. And where the issue is never raised, okay, we don't know the facts. That seems to me to be quite a problem for your argument. You want to overturn a judgment here on the grounds of lack of subject matter jurisdiction, where because no one said, hey, we need to take some evidence on this, we have what we have in terms of a record.
Respectfully, Your Honor, I'm going to disagree with you. I think that because subject matter jurisdiction.
That's fine. That's what I expect that.
But I'm doing it respectfully. I think because subject matter jurisdiction can be raised at any time, the fact that it perhaps was not raised at the temporary custody hearing is not as important as the fact that the judge number one, who I believe was a man, I believe because he raised it.
But that's why I'm saying that, and that my little discussion that I launched into was right here. What exactly did he say? You say he raised subject matter jurisdiction. What I remember reading is words to the effect of, geez, I think I better call the judge in North Carolina because they have a different view on this.
Oh, well, that was much later, Your Honor. This case was filed in 2016. It did not end until 2022. So this
So what is the statement that you're saying, quote, raised subject matter jurisdiction?
Well, that was my understanding too. That there's this issue about whether another state is asserting jurisdiction, and you don't want to get in a fight with another state that's asserting jurisdiction. I think that seems to me that was the concern.
I don't recall exactly what the judge said, and I would be happy to respond by letter. What I can.
We can read the transcript.
What I can say is that the DCF attorney at that time responded, as it turns out, incorrectly and said, oh, mother's lived in Massachusetts for well over a year. There was no reference made to the fact that mother had left the Commonwealth, chosen to leave the Commonwealth and returned to North Carolina. And from my perspective, that's the issue here. Had mother stayed in Massachusetts from the time her mother sent her here through having the baby and having the baby removed, I don't know that we would have a jurisdictional issue because Massachusetts would qualify under 209B Section 1 as the home state of the child.
Why
But-
doesn't it qualify as the home state of the child regardless of what mother did or didn't do?
Because I think, because mother,
The Commonwealth is the home state of the child in the commencement of custody proceeding. At that point, the child's in Massachusetts. In fact, the child has not been in any other state at all.
but the point that I'm making is that Massachusetts was not the child's home state at the time that the petition was filed. Mother did not return to Massachusetts to continue to reside in Massachusetts. She returned to Massachusetts from North Carolina.
Stop. Why does the intent of mother even matter? I'm reading the language of the statute. Commonwealth's a home state of the child. The child has lived in Massachusetts its entire life. Why does mother's intent matter? Is there a case that's going to say, oh, because, if the mom travels to Georgia and gives birth in Georgia, but everybody knows she intends to come back to Massachusetts, Georgia can't be the home state of the child. Do we have case law on this?
I think perhaps I'm not making myself clear, and I apologize for that. Mother was sent to Massachusetts by her own mother as a minor to come here. The first decision that's in the record about mother taking action to reside somewhere, to be a resident somewhere, is when she returns to North Carolina with the child, with father.
Why isn't she residing in Massachusetts? I mean, you want to insert the word temporary, but again, we don't have any issues never raised. We don't have any fact-finding on this. The objective facts are she was living in Massachusetts for 4 months before the child was born and for 3 months after the child was born. Where do we get the word temporary from is my question.
I'm not saying, I wouldn't call it temporary, but then she moved. That's the point that I'm making, is this is no different than.
Moved without the child.
No, she moved with the child, Your Honor. Father came to Massachusetts, picked up mother and the child, and they went back to North Carolina. When mother returned to Massachusetts, it was just to get her stuff. It wasn't to resume.
No finding on that, though.
There's no finding because the judge didn't make the finding, but there's
What I
mother's
asked for.
testimony in the record.
Now we're in a circle. Okay.
How long was she in North Carolina at that point?
I'm sorry?
How long was she in North Carolina?
I don't know. I don't know. It's not clear to me from the record. And that's why, had the judge on November 7th, 2017, actually engaged in some sort of fact-finding to determine whether or not Massachusetts could assert ongoing jurisdiction beyond the emergency jurisdiction that it very clearly had under 209B. I don't dispute that at all. And in fact, on 6.
So this is the place where I think maybe you and I are talking at cross purposes. What facts do you think would have satisfied a judge in 2017 that Massachusetts was not the home state of the child?
I think if she'd queried mother or father as to where they were actually residing at that time, if mother had said, well, I live in North Carolina, then she's temporarily in Massachusetts to retrieve her belongings. That doesn't qualify under 209B Section 1, the definition of home state. At that point in time.
Because why? I'm looking at the language.
Because at that point in time, she was residing.
So if the Commonwealth had been the child's home state within 6 months before the date of commencement of the proceeding, temporary or not, if you got 6 months, it's Massachusetts is the home state. You agree with that, right?
I would agree with that.
Okay. So all the child had to be there was for 6 months. But the child had only been there for 3 because that was its entire lifetime.
Right.
And the rest of the sentence says, had been there for 6 months before the date of commencement of proceeding, and the child is absent from the Commonwealth because of his or her removal. Wait, isn't there some place where it says, I'm sorry, I'm not.
Periods of temporary
Or for the
removal.
child's entire life, right? Isn't there something that says that? Okay, maybe I'm missing it.
I think the distinction that I'm trying to make here is that at the time that mother came to Massachusetts to retrieve her belongings, that would be no different than someone who had resided, was on vacation and not residing in Massachusetts, but was there temporarily just to achieve a particular purpose. And I think the problem is that the fact-finding wasn't adequate. The issue of jurisdiction was raised 6 times by 3 different judges in this case. It was raised on November 7th, 2017, 9/15/2020, 11/24/2020, 3/4/2021, 3/23/21, 4/12/21. On 3/4,
So if the issue is raised by the judge and mother and father don't contest it, I know subject matter jurisdiction can always be raised, but it was raised and nobody objected to it. Isn't that somewhat a waiver in this type of situation?
I don't think it is a waiver because there's.
So a judge on his or her own should have undertaken a factual evidentiary hearing when nobody's asking for it and nobody is contesting, yes, you have jurisdiction.
I think if you read what the judge said, the last judge who ultimately heard the trial in this case and issued the findings of fact, she noted on November 24th, 2020, she says, North Carolina has particular rules around jurisdiction. She noted that she had had a case that was remanded on the issue of jurisdiction from North Carolina. North Carolina has particular rules around jurisdiction, and she whether mother was a resident at that time. And then she recessed the case to communicate with the judge in North Carolina to determine proper jurisdiction. At the next hearing on 3/4/21, the judge, again, same judge, again, questions jurisdiction and schedules another date so that she can communicate with the judge in North Carolina. On 3/23, the judge again questions jurisdiction.
Why,
Again,
okay, all right. Read that all in the brief. I'm sorry to interrupt you, but I'm still back in I think it's 2016, okay? I've now found the definition that I was looking for. It's the definition of home state. The state in which the child immediately preceding the date of commencement of the custody proceeding resided with his parents, a parent, or a person acting as a parent for at least 6 consecutive months. We don't have that because it was only 3 months old.
Mm-hmm.
And in the case of a child less than 6 months old, the state in which the child lived from birth with any of the persons mentioned.
provided that one of the parents continues to reside there.
That doesn't say that here. Doesn't say it. I mean, I'm reading the definition of home state, and
Right.
I'm struggling with the concept that you've been sort of, it's implicit in your argument, but it doesn't fit the language of the statute.
So we might have to look at the language of the statute on our own here since we're over time.
Thank you, Your
So,
Honor. As to
unless you
the,
wanna-
No,
Okay.
I mean, if you have an answer, I think you should give it now.
I think that at the time that the care and protection petition was filed, mother was living in North Carolina. And at that point, while Massachusetts could exercise emergency jurisdiction under 209B, it was incumbent upon Massachusetts to query the judge in North Carolina to determine whether or not North Carolina intended to assert jurisdiction, because
Let me make sure I have the facts right. When the mother leaves when does she leave? April?
in 2016,
She takes a child with her,
she does.
and then she comes back, and that's when the proceedings are initiated?
Yes, because they were afraid that she would flee with the child. If we're going to use that word, she'd already flown.
I'm sorry, finding of fact 56 and 57. In April, she's terminated from the shelter program. Following her shelter termination, the child's removed and placed in Massachusetts with a family. And then mother subsequently returns to North Carolina to live.
It's technically true, but it's also technically incomplete, because what the judge omitted there was in between being notified that she was being terminated from the shelter and the filing of the care and protection petition, mother testified that father came, she called father, asked him to come pick her up because she had nowhere to live in Massachusetts. He did so, and she went to North Carolina. She returned to Massachusetts to retrieve her belongings.
Okay.
And my
got it.
argument is that intervening move to North Carolina usurped the jurisdiction, the ongoing jurisdiction of the court in Massachusetts. I would rest on my brief with respect to the impropriety of the foster parents. Thank you, Your Honors.
Thank you. So the department and the child are splitting 8-7?
Good morning, may it please the court, Julie Gallup on behalf of the Department of Children and Families. Massachusetts was child's home state, so the juvenile court correctly exercised jurisdiction over this matter.
What do you say to the argument that was just made? I mean, as I understand the argument, it is the child was here for 3 months. Mom intended to go to North Carolina, took the child to North Carolina. And the care and protection didn't begin until she sort of was grabbed on the way the argument is being made. She was sort of interdicted on the way back. She came back to get her stuff, and they said, okay, now the child's in Massachusetts, and we're going to send the child someplace else. What do you say to that?
So in my brief, I cite to mother's testimony at transcript 1207, where she's questioned about the return to Massachusetts and the shelter from that brief trip, and she's asked...
Do we know the length of the trip from the testimony?
It's not clear to me. It could be in there, but I don't know if it's there right now. But she said, she's asked, were you intending on leaving the shelter? And she said just then, no, or something to that effect. So...
The word no appears in the answer. I remember reading it in your brief now, but I don't remember reading it in the transcript. But that's what you're representing to us.
I mean, I hope that I correctly reflected the transcript.
She was intending on not leaving the shelter until she gets kicked out of the shelter. The question is, when she goes to North Carolina, was it ever asked, did you intend with the child on staying in North Carolina permanently? That's not asked, is it?
I don't believe it is.
I think it's fair to say she didn't want to get terminated from the shelter. So when she's asked, did you intend on leaving the shelter, the answer is no. But that's not the important question. The important question is, what were you going to do after that? And if the answer is, I was going to go to North Carolina, I was going to stay in North Carolina, and I only came back to Massachusetts to get my stuff, which is what opposing counsel is saying, is that a fair interpretation of the testimony that the judge didn't even really reference?
So it's my understanding that definition of home state includes, like, brief, a parent can leave the state briefly and return, and Massachusetts would remain the child's home state, especially when it's been the child's home state now since he was under 6 months of age when the case was filed, from birth until the case being filed. So a parent can leave the Commonwealth with the child, but that doesn't necessarily mean that, because she was there for a few days, all of a sudden now North Carolina becomes child's home state.
Huh. There's also Georgia's in here too, right?
So, Georgia is in there, but that's after the case has already been filed and the parents are moving between North Carolina and Georgia. So, and Massachusetts does not lose home state jurisdiction because the parents, once the case has been filed, Massachusetts has jurisdiction over the child. Now, when it can lose home state jurisdiction, that only occurs when we have like some type of judgment, and then a subsequent matter is filed somewhere else, or, there's competing cases in different courts. But we never had any judgment.
Well, we have, I think, this is memory, so correct me if I'm wrong, the ICPC in North Carolina takes place, and the child, sort of based on that, then gets reunited with mom in North Carolina. So there is some type of order, in effect, uniting mom and child in North Carolina as if North Carolina is going to be where the child lives. So isn't that sort of a premonition of jurisdiction?
The purpose of the Child Custody Jurisdiction Act is to ensure that there aren't competing cases in different states. And we didn't have any other case in any other state in this matter. So,
Can I ask a different question?
Please.
It's related to what Judge D'Angelo just asked. So, there is this event where their child and mom are reunited by Massachusetts in North Carolina in 2018. At that point, is there any ceding of jurisdiction going on? Because what we know is shortly thereafter, within what, 3-4 months, the child is removed again by I think by DCF, right? So DCF asserts its jurisdiction and says, even though you're in North Carolina, give us the child back. And no one objects to that at that time, right? How does that happen? Is it in the record how that happened?
I don't want to misspeak, but I believe there was involvement with Child Protective Services. I think the child was removed from Georgia.
Oh.
Because mom was moving between North Carolina and Georgia.
Yes,
And so there was like a report, and then child was removed at that point.
Not from North Carolina, but from Georgia.
And that was also
Because
the issue with the
child was
ICPC.
with mom. The child was with grandmother, right?
Yeah.
Maternal grandmother. And the report is mom is leaving the child with maternal grandmother for extended periods of time. And at that point, Massachusetts gets involved, takes the child back.
Correct. That's my understanding of the facts and
What does the
information.
record show about how that was done? But that's actually not with North Carolina anyway, as you point out. It's with Georgia.
From memory, I believe there was some type of incident or event.
Here's what's in my head, and I don't know the answer. Ordinarily, I would think that if the Massachusetts DCF want to take a child from Georgia and bring it back to Massachusetts, they might tell somebody in Georgia that they're doing that.
And that's what I'm saying. I believe that there was involvement with the Child Protective Services in that state, which led to child returning to Massachusetts.
Okay.
So,
So can you explain, if Attorney Driscoll-Weiss says that during six different hearings, judges raised this issue, but then it was, why didn't it go anywhere?
I can't speak to all of those different incidents from my memory. What I do recall is that the attorneys mentioned this, and then at a pretrial hearing, the judge then asked mom if she had lived in Massachusetts for 6 months before the care and protection was filed. Mom answered yes, and that was at transcript 741. And then when asked if she was resident of Massachusetts when she gave birth to child, mother responded yes, and that's at transcript 777.
And so, because of the interstate agreement, there's interaction with protective services in both North Carolina and in Georgia, right? And I take it there's nothing on the record that any of those states took jurisdiction or wanted jurisdiction? Or do we not know?
It's not my understanding that those states filed any type of case that included this child. There might have been.
Can we infer from the conversations that opposing counsel referred to where the judge is apparently speaking to a judge or somebody in North Carolina that North Carolina didn't want jurisdiction of the child?
No, I don't think that we can infer that, because I think that there needs to be some action. I mean, if you're talking about whether the North Carolina judge is declining jurisdiction, there needs to be some type of, something in the record that that any judge in North Carolina is aware and then makes a decision, and we don't have that.
Massachusetts asked for an ICPC evaluation of the North Carolina home, right?
Yes. I believe on
So
multiple occasions.
An ICPC was conducted in North Carolina.
Yes.
And no one in North Carolina said, hey, actually, we think we have jurisdiction over this child.
The way that I understand the ICPC process is that it's, it's through the child protective agencies, that the social workers, I don't know if they would necessarily be doing any type of legal analysis on the case, but in the record, we don't have any information about North Carolina through the ICPC process raising an issue about what's going on here with Massachusetts, a Massachusetts court, making orders for this child. Seeing that my time is up, if there are no other questions, I would rest on my brief.
Thank you. We'll hear from Attorney Bernardi for the child.
Good afternoon, or morning, sorry, it's almost afternoon. Christine Bernardi on behalf of the minor child in this matter, if it please the court. To address some of the questions that the court has raised in regards to the jurisdictional issue in this matter and whether or not Massachusetts should have taken jurisdiction in this case. One question was asked about the date of April 12th and April 13th. In this case, the child was taken into custody by the Department of Children and Families on April 12th on an emergency basis under 119, Section 51B. On April 13th of 2016, the petition was filed. Mother was present in court according to the docket sheets on this case. And I don't have the exact site to the brief where it is, but it's page 5 of the docket sheets. It says mother was present for that hearing.
Wait, so I want to make sure that's clear, because that's not in the findings of the judge. And I'm looking at Record Appendix 2, page 144. On April 11th, mom is terminated. And then it says, following the termination, the child is removed from mom's custody. That is different than what opposing counsel is saying. So I want to make sure we're clear. So the child never went to another state before it was taken away?
Your Honor, my understanding from the record is that mother had taken a short trip, and I believe it was father's testimony. It wasn't mother's testimony, but father's testimony that she had taken. After she had been told she was being terminated from the shelter, she then contacted father according to father's testimony. And father came and picked up mother, went for a short visit in North Carolina. She returned to Massachusetts. There's no dates or times as to when that occurred, but it was after the notice of being terminated from the shelter.
Do we know the date?
My understanding, the date of the notice of termination of the shelter was April 11th.
This was a very short trip to North Carolina then. She's present in court in Massachusetts on the 13th or the 12th?
On the 13th, she's present in court. She's back on the 12th.
So she's kicked out of the shelter on April 11th, according
I think that's the
according
date
to
she's
the findings.
supposed to leave the shelter, is on April 11th.
Okay, so we don't know when she left.
We don't know when she left.
That's helpful, sorry. Okay.
Okay, but on the 13th of April, there's a preliminary hearing, not a 72-hour hearing. In Boston Juvenile Court, there's a tendency to do things different from many of the other courts, where you get 2 bites at the apple. You get a preliminary hearing. If parents show up, they're heard. And so mother showed up. She was present in court on the 13th. And on the 13th, she waived her 72-hour hearing. You were asking that question. So there was no temporary custody hearing in this case. There was only a preliminary hearing. So that's one of the answers to the questions that you are all asking. Another question you asked was regarding the ICPC, the Interstate Compact for the Protection of Children. So the ICPC kicks in when the sending state has to, by law, for the child to get any kind of services or to be accepted into the other state, an ICPC request is sent to the other state for that state to do a home study to determine whether or not it's an appropriate home for that child to be placed in.
Presumably, if there was a care and protection proceeding that had already been initiated in North Carolina, they would have figured out that maybe ICPC was a problem, right?
Yeah, there would have been no need for an ICPC.
Exactly. They already had jurisdiction over the child. So we can infer from the lack of that response and them going through an ICPC that there's at least no proceeding in North Carolina.
Correct.
And no assertion by North Carolina is in the record that says, you know what, actually mom is from North Carolina, dad is from North Carolina, we should have jurisdiction over this child.
And there was no effort by father to file a case in North Carolina requesting custody of his child or a paternity case or anything to bring any action in a North Carolina court. So once the child's in, and to go back to the ICPC issue, Massachusetts maintains jurisdiction over any child under an ICPC so long as the matter remains open in Massachusetts. So Massachusetts maintained that jurisdiction, and generally speaking, it is not Georgia or North Carolina that brings the child back here. DCF sends a social worker down to pick up a child, and the child comes back with 1 or 2 social workers. That's the practice. So you are asking that question as well.
So they do it unaccompanied by somebody from the home state?
Pardon me?
They would do it unaccompanied by somebody from the services in that state?
They would pick up, Massachusetts goes and picks up the child.
The reason I think that you're seeing somewhat incredulous looks are that if there's any kind of issue with the person you're trying to take the child away from, you got to tell the state you're in. There's got to be somebody who can...
What prompted the removal of this child was a 51A being, what they call in Georgia and North Carolina, a 51A being filed against mother in that state.
Right, so...
Based regarding another child who was placed in a closet because she couldn't handle the child screaming. And it was an infant that had been placed in a closet.
Not this child, that was a different child, or was it this child?
It was a different child. It was another one of her children that was placed in the closet. And Massachusetts was very concerned about mother's mental health at the time.
But is there, when Massachusetts goes to another state to pick up a child that they're claiming jurisdiction over, is there a practice that I would think might be like even in a regulation that says, hey, you got to give a heads up to the state that you're taking the child out of, and they need to accompany you when you go and you pick up the child?
Generally speaking, and again, the practice is, yes, they inform the other state they're coming, because it's the ICPC. They're communicating with the other office. The ICPC office in North Carolina and the Massachusetts ICPC office are communicating with each other in regards to that issue.
Remind me, at the end of so the child is with the maternal grandparents? At the end.
She was with now?
Yeah, I mean,
where is my client now?
At the end of the trial, yeah.
My client now is with the maternal grandfather and the maternal step-grandmother.
There's issues about that raised in the brief as well.
I'm sorry?
There's issues about that raised in the father's brief.
Yes, there are questions that are raised, but to address the court on that issue.
No, actually, do you need to? The time's up. Let's hear if we have any questions.
The only question I would have is that what the briefs say is that the allegations that are raised and that the point that's made is, look, the judge never addresses them. The response I've seen is those allegations were each investigated and unsupported by the department. Is that accurate?
That is accurate, Your Honor, and that's my argument in my brief.
Okay.
There are no further questions. I rest on my brief and my argument.
Thank you all. You gave us a lot to think about.
Thank you.
And cases submitted. Okay, number 5 for today is 23P415 Marx versus Brooks. Actually, you could point it up to you. It would be helpful. We're recording this.
Sure.
Yeah, just make sure the mic is facing your...
Can you hear me? I'm pretty clear with voice, so we should be okay. May I?
Yes.
So I see it's still morning. Good morning. My name is Howard D'Amico. I am counsel to Patricia Brooks here, and may it please the court. What I'd like to start with this morning is just a structure from a case I've cited in my brief. This is the Sachs case. And one of the phrases in the Sachs case that strikes me is this concept that without precision, an order can become an instrument of severity. And I think that's the issue in the case we have here. So the lawyers on this side, we spend our time in courthouses. We seek to obtain orders. I seek preliminary injunctions very often at the start of cases. Everyone has to follow a court order. That's the whole system we work on.
Counsel, court orders by the parties also have to be read a little bit with common sense.
No question.
And the way I read your argument, if there is an order regarding property, your argument is almost like somebody couldn't move it from one room to another. unless the order specifically says, don't move it from one room to another.
No. That's not the way I make that
Is
argument.
there any question that the parties, that the property that was moved at the time of this injunction was in dispute? I mean, that's what the fight was partially over, was this property. And the court said they made the injunction over that property.
So there are two different issues here, Your Honor, that separate. One is this issue of my question as to whether the word removal is specific enough for the type of contempt.
I understand, but my question
The other is,
did the parties understand that the property was in dispute? And that's what the court was acting on.
so, Your Honor, the whole point from our perspective is, and plaintiff's counsel has referred to the order repeatedly, even here, as a status quo order. That's a lawyer phrase. That's a court phrase. It's a paraphrase. The specificity of the order that was handed to a non-lawyer said she was restrained from removing, transferring, or encumbering the plaintiff's property.
That's not what it says. It says enjoined from removing, selling, or transferring.
I apologize.
Okay, well, but the word selling is kind of important.
It will, no question.
Okay.
And I apologize. I didn't mean, for the moment, I was focusing on the word removing. Right.
You've got two issues. You got a removing issue and you got a selling issue. You want to deal with the removing issue first.
So if we deal with the removing issue, that's my issue that I started with. One of the cases that came to me here, Mr. Gordon raised, but it's a sentinel case here, is this Demoulas case. And the Demoulas case hits on the word ordinary. And the Demoulas court says, look, there's a certain point where we can't drill down further. And that may be on the word ordinary.
Counsel, I want to go back to what I said initially.
Sure.
So it says do not remove the property.
Correct.
Okay? So are you saying that if there is property in room A and one of the owners says, you know, it's in the way, I need to move it, and they move it from room A to room C, that is not a violation of the order, or that is a violation of the order?
I'm saying that because that specific example, Your Honor, would be unclear from the word used in the order, you could not be held in contempt of that order without more clarity in a record as to what that party understood to be their limitations.
So if your client moves it from room A to room B, and while they're moving it from room A to room B, it gets destroyed. That's a problem, isn't it?
It's a problem vis-a-vis the underlying counts in the complaint, but it's not a problem with regard to the contempt of the order. And Your Honor, that is our position, that I understand what you're saying. And so I can take this to the extreme against me. The extreme would be if you had a goldfish, and there was an order that you couldn't remove the assets, and you remove the goldfish from the tank to the side. The goldfish would die. And I might argue, someone might argue that that might be clearer. You really can't do that. I think, and it's in our record that Ms. Brooks testifies. She testifies, she says, nothing left. Everything is still there. We didn't junk anything.
Well, that's not true either. She sold the car and she sold the, right?
You're correct.
So,
you're correct.
Can we flip
That's
things?
her testimony, but you're correct.
Can we flip things?
Sure.
Yeah, maybe she said nothing moved, but it's not true, right? And the judge didn't find that. So the question is whether your client's in contempt.
Sure.
Right?
Yes.
Let's talk about the selling.
I'm sorry?
Let's talk about the selling. She sold
Sure.
the Toyota. She sold the
Trailer.
The trailer.
Sure.
They're on this list from 2017. Okay. The judge discredits her testimony. I own the car. Why isn't that the end of the story? She is in contempt.
It's not the end of the story, Your Honor, because her testimony is that she owned the vehicles, and
The judge discredited it.
that was discredited, but the order says items of the plaintiff.
Counsel, this is why I started with, was there any question that those items were in dispute?
With regard...
So if they're in dispute, the court is saying, don't sell the property that's in dispute, and then your client says, well, I thought it was mine, so I sold it. How is that not a violation?
Your Honor, with all respect, I categorically disagree with that assessment. If the word in the order is don't remove items of the plaintiff, and somebody thinks they're their items, the order could have been made, could have been asked for to say don't remove the items in dispute.
And someone thinks they're their items?
Yes.
That can't possibly be right. The judge found that he discredited her testimony that they were hers.
He found her in contempt. There's no finding.
Well, go ahead.
There's no finding that he says that I discredit her testimony. Mr. Gordon says that, and a summation...
No, Brooks testified that she believed she was the owner of the Toyota and the covered trailer, while Marx testified the opposite. The court credits the testimony of Marx on this matter and does not find Brooks's testimony credible.
What do we do with that?
So it's
clear error?
No, it's not clear error.
Well, if it's not clear error, then I can't see how you can get around it.
If she still testifies that way, even if he discredits it, the issue is that if she believed it, she's still entitled to not transfer, to not be in violation of the order.
It wouldn't be clear disobedience, would be your point. But wouldn't you have to convince the judge of that?
Pardon?
Wouldn't you, I'm sorry. I keep doing this and it's my fault. Wouldn't you have to convince the judge that she actually believed that she owned it and so it was not clear disobedience of the order? She didn't convince the judge. She testified and he disagreed with her.
I understand that. He discredited her testimony, but he didn't, she's still the one that gets to avow as to whether or not at the time she did what she did, she had a belief as to whether she was complying with the order or not.
It can't possibly be right, because then any defendant in a contempt action can say, well, I didn't think I was violating the order, and they can get around it.
The order says that she can't transfer anything of the plaintiff.
Correct.
She believes the record shows two items that had title, or I think there was a transfer of title or a release of title that were both in her name. Those are in the record.
So that's a clear error argument. That's different than a subjective belief argument. The subjective belief argument, I said it can't be right. It cannot be that a defendant in a contempt case can say, I didn't think I was violating the order. If the order is clear, then the disobedience is also clear.
I concede that on the ownership of the two items, I think that is a different issue, because to your point, it's the word selling.
Yeah.
And so I do nonetheless take a position, whether I want to argue it's clear error or not,
that's what I hear you saying.
I'll adopt that argument for this afternoon, Your Honor.
I think it has to be your argument or not be your argument. A few moments ago it wasn't. Now I hear you saying the judge made a clearly erroneous decision in rejecting her testimony that it was hers because there was evidence in the record that the title was in her name. Is that the argument?
That is the argument.
And what about the list of 60 items that are apparently his? That's on the list of 60, right? Was that an agreed-to list?
So, there is a list of 60 items. This issue gets confused both in the trial and in this part of the case. Her testimony is, yes, I was familiar with a list. I was familiar with my counsel gave a list back to Mr. Gordon. But she makes it clear those two items were hers. She doesn't directly adopt the list. And so again,
did her attorney adopt the list on her behalf in the litigation?
No, not in a contempt proceeding.
Oh, before the contempt proceeding, at the time of the injunction, there was a list. That was the list that they were discussing.
No, that's not in the record.
The list comes after the injunction?
The list is around, it's circulating, but it's not in any manner. We had this discussion in the Superior Court yesterday on remaining parts of this case. No,
mean, are there still remaining parts of the case?
Pardon?
Are the case is still ongoing?
There are.
Okay, so I mean, so then whether or not there's a contempt on the stuff that was left in the yard to the weather, that can be there can be recovery for that without a contempt.
Correct.
Okay.
The parts of the case have already been decided with regard to that
The case has
issue.
gone to final judgment after trial, hasn't it?
No.
There's been a trial?
There's been a jury trial on multiple counts. There were 2 remaining issues, 2 counts, I think a constructive trust count and a replevin count. Those were reserved for the judge. It would take far more than my 15 minutes to get to.
No, that's all right, and it's outside the record, too.
Yeah.
Right.
Are you representing, I don't know how to pronounce the name, is it Chrysidlo?
I'm also representing Mr. Chrysidlo in this proceeding, Your Honor, and I concede we did not file a reply brief, which should have more appropriately on paper addressed the items and the references contained both in Mr. Gordon's notice of appeal and then his appellate brief.
So I have 2 questions on that.
Sure.
Okay? Do you have more, Judge Massa?
I'm sure they're the same questions. Go ahead.
Well,
No, go.
so my first question, I've forgotten them now. No, my first question is, Chrysidlo says in a number of, and I just couldn't figure out because nobody addressed it.
Sure.
He says, come pick up your property.
Sure.
What happened? Did he come pick up some property? Did Marx come and pick up some property in response to the multiple letters in 2022 that said, come pick up your property?
Without precision, an order can become an instant of severity. No, Your Honor, he has not yet come to pick up his items. In 7 years, 8 years, he has not yet come to pick up the items he so desperately is concerned about.
Does the order that the party and their officers, agents, servants, and those in concert, does the order apply to Chrysidlo?
So here, I fully agree with Judge Wren's decision, where he indicated he did not find that Mr. Chrysidlo was made a part of the order because, again, there, he wasn't served with the order under 65D.
Doesn't have to be.
No, he doesn't, but he wasn't. And then the
But he
judge
doesn't
didn't find
have to be.
constructive.
So on this one, the argument is, there was clear error. The judge finds that your client, Chrysidlo, did not have notice.
Correct.
I mean, we have a letter which not only tells him about the order, it quotes the order without putting it in quotation marks, and your client responds to it. How is it not clear error for the judge to find your client didn't have notice?
So, Your Honor, again, from where I started, if lawyers could start to categorize or summarize what orders are and have that be effective on a party, would unemployed judges or clerks typing up orders? There was an opportunity to serve this order, at least to get him a full copy of the order.
Could have done
that
better.
was missed.
He could have done better, but the question is notice,
Yes.
right? And there's a finding that your client did not have notice.
Correct.
And they are challenging that as clear error. And I'm asking you, when your client responded to a letter that said there is this order and comes very close to quoting it verbatim, isn't there clear error?
No, he doesn't say this order. He says, I'm aware that there's been some mention that there is an order. I'm not aware of the order. I don't know of the order. Could he have had an affirmative obligation to go out and get a copy of an order if he's been told there's an order? I don't think so. I don't think that rises to the level of creating that obligation. A lawyer has told him there's an order and here's about what it means. I think Judge Wren correctly found that that was insufficient. Again, going back to the purpose of what we do with our court orders, if they're to bind a party.
Was there an argument made? I'm looking at that letter.
Sure.
And I'm thinking, geez, when you say to them, come pick up your property, and they don't, was there some argument made about, I don't know, a waiver or, a defense to any kind of contempt proceeding?
So there are things that happen in the trial court, Your Honor, that don't necessarily create a full record. I handed 6 or tried to hand 6 emails to the court at one point, and the court didn't want to see them. We have a case in 35 years in the trial court. I've never seen a case that left our trial judges more flummoxed. And I will leave it at that.
Okay, well, thank you. We'll hear the other side of the story.
Oh, it is afternoon. If I may, I'd like to go backwards.
You're Attorney Gordon, right?
Yes, I'm
Okay,
sorry.
thank
Regarding the list, that list was authored by the defendant Brooks. The testimony in the record, and I think it's in my brief, says she was cross-examined on it. She said she reviewed it and authorized the list to be sent to me.
Prior to the injunction?
No, this was after the injunction, but before the items were removed. Okay, this was the list.
Where the items were moved from where they were to
Right.
another place.
Right.
So, but surely she wasn't agreeing that they were all your client's property.
Well, the list says, "Come get them."
What's that?
They wanted Marx to come get the items. They said, "These are his items." If you look at the list, it says.
Why didn't your client do that? That seems to me to be a pretty quick answer to this problem.
Because we couldn't, Judge. We could never make arrangements to pick up the items. There was always, "Come get them," and even Judge Wren one day, he and Judge Kenton Walker were the 2 judges on this case. Judge Wren one day sat there, I said, "Can we come get them?" And there was this argument, well, we don't know, and he just blurted out. He said, "He's been trying to get them for 6.5 years. Why can't he come pick them up?" And we could never get a date. And in fact, just recently, last year.
Your client went to the property in 2022.
Right.
Pursuant to a court order.
It was agreed upon. It was agreed upon that we could get in there and get the items at that time.
And then what happened?
We went out there. I was there. We went out there. We were supposed to have access to the upper garage and to the basement. We got there. We were not allowed. The garage was locked. The upper garage was locked. The basement was locked. I tried to call both counsel at the time repeatedly, and while I was there, and I never got a phone call back.
Did you ever ask Judge Wren, in light of these emails that said, "Come pick up the property," to enter an order requiring the defendants to get out of the way so you could come pick up the property?
I did not.
Why not?
Well, he kept saying to make the arrangements, and we kept trying to make the arrangements, and
we're outside the record.
Right.
I have trouble understanding what we're arguing about, because I read letters that seem to me to make sense, that say, "Come pick up the property,"
Right.
and then it was never picked up.
and he would have gone out to pick it up. It was an expensive proposition to go do it, but we just couldn't get there because we could. In fact, if you look at one of the issues that came up in the case, we were supposed to go out there for an inspection. We showed up, and we weren't allowed in the house even with a court order.
Can we go back to the record for
go
a
ahead.
second?
I'm
I
sorry.
want to try to break this up. Within the 60-item list,
Yes.
which is after the injunction is put into place,
Correct.
were the car and the trailer on that list?
Yes, the Corvette, the trailer, and the Toyota were on the list.
I want to break it up.
Okay.
And after that list was agreed, seems like from your perspective it was agreed to, it's after that list that they're sold?
That they're put outside? Yeah, okay.
No, first the
Yes.
ones that were sold.
The sold, yes.
Okay.
The sale
And then
takes
the
place-
other items were moved.
Correct. They were put outside, and it was acknowledged that those were Marx's items before they were put outside. Mr.
And so
Crisidlo,
where is that in the record?
Crisidlo's letter to Marx said,
Right.
I'm going to put your stuff outside, come get it, or it's going to be trashed or sold off, okay?
There he's not denying that they're your clients. There he's denying that he removed them.
Pardon?
He's not denying that those items are your clients. He's denying that she removed them.
No.
So,
well,
I mean,
I think in the brief, they were arguing that they were not Marx's items.
that's the stuff that was sold. Right.
In the other, well,
so let's talk about removing. Would it violate the judge's injunction to move your client's property in her house from one room to, say, the garage? Is that removing?
Technically, that would be removing, but I will.
You're removing. Move it, but you wouldn't file a contempt on that because your property is in. Okay.
If you read our brief, there was an inspection done in 2020, and after the suit was begun, 2 years afterwards. We went in, we had to get an order, we went in, we did it, Marx went in, I went with him, we went through the house, everything seemed to be there, and that's right in it, we agree. Everything seemed to be there, maybe not exactly where it was, but it was all intact and there were no problems with it. Brooks, for 2.5 years after the order entered, appeared to comply with it by not moving anything. The problem is not that, let's say it was moved, the problem is that the parts, the cars and the other things were, in my view, intentionally and maliciously put outside in the winter.
And definitely that's a nasty thing to do, but does that violate the judge's order?
Yes, I think that is a moving. That is removing it from the enclosed garage.
But now you're adding words.
No, I don't think so.
Yeah, the word is remove. It's not remove from the enclosed garage to outside.
All right, I'm trying to be practically speaking. If we went in there and even if the stuff were moved around in the house, it was not damaged, I wouldn't be here.
You wouldn't be here, but your argument is it would still be a violation of the order.
It would still be a violation.
So if you move, now I'll ask you, so if you move it from room A to room B, technically under your reading, it's a removal from room A, and therefore it's a violation of the order.
And their other argument was moving means that it had to go out of their possession off the premises. That was one of their arguments that they brought up in Superior Court, and I think it's in their brief also.
Why is that an unreasonable reading of the injunction?
What's that? Which one?
That in order to remove the property, it would mean taking it off the property. In other words, in order to remove his personal property, it would involve taking his personal property and having it leave the premises. That's removal. Moving it from, look, they're living there for years. Presumably, they're allowed to take this thing and move it over here. They got to clean sometimes, don't they?
Well, this stuff was in the basement garage.
Did you know that?
Huh?
It's not a reasonable, in my view, interpretation that they can't move it within a closed space. Your argument has to be that, as applied, they understood that taking it and leaving it out in the cold winter was was different in kind than moving it from point A to point B.
That's my point. As I said, we wouldn't be here if practically speaking, we wouldn't be here if it was.
Now we're interpreting a word and sort of trying to carve it up. And so that leads to the question of what does Burchell mean when it says it has to be clear disobedience of a clear order?
But there's room for interpretation under the case law as to what a reasonable interpretation or reasonable meaning of the word is. And the courts are allowed to apply a reasonable interpretation to what the order means.
Well, what's your best case on that? But your best case that you said.
You would ask me that. I cited.
Yeah, we always do that.
It's cited. I don't remember.
Moulis, I think, is the one you cite.
Moulis. I think there was another one on that issue also.
Sometimes trial judges, which I have a little experience on.
Yes, we know.
Yes, as you know, draft orders based on what one of the parties suggests is good language in the order. Is that what happened in this case?
That's not the language I suggested.
What was the language? And first I should say, is this in the record? What you proposed?
I think it's in the record, so yes.
So you didn't use the word removal. What did you use?
I think I was more specific about it. I just don't remember, I'm sorry. It was.
But you think it's in the record?
I submitted a proposed order with the motion.
Okay.
Okay, so it's.
And you think that's in the record somewhere?
It should be on the docket sheet. Yeah, it should be, I think it's right on the docket sheet. I don't I'm sorry, I just.
Okay.
I didn't expect, but I did submit, the argument that that was my language is not accurate. I submitted an order, and that was the judge's determination on how.
Barring the defendant from disposing of, removing, or otherwise disposing of, or taking any action regarding Marx's personal property, and that property remain on the premises pending further order. RA 126.
Okay, I'm sorry. That's in the docket sheet? Yes?
It's in the appendix.
Can I ask a different question? Does it matter? There are two different contempts here. One is the sale, and the other is the moving of the property and other property and leaving it outside. Even if we were to agree with your opponent that the removal outside can't be a contempt, isn't there still a basis for the contempt and the selling of the other two?
Absolutely. Absolutely.
And would anything, let's assume that we only found that as a contempt. Is there anything about the remedies or what has been granted along with that that would necessarily change because the scope of the remedy was broader?
Not now, because part of the case went to trial. And there was a jury verdict that came back from MARX on a conversion which dealt with the damage to the property, the car parts and everything that were put out in the weather. And Judge Wren, if you read it, was fastidiously staying away from that issue. He did not want to in any way invade the jury's province of finding ownership or whatever. He was very, he didn't want to do that. So
the Judge Wren orders escrow of $15,000 representing the estimate as to the dollar amount of damages done to the disputed property left in the yard. So of this contempt, 15 of the $20,000 is about the stuff that's left in the yard.
Right. I thought it was 20,000 total.
Total, yeah.
Yeah, it was 20 total.
But we now have a jury verdict, and that was just an escrow anyway, right?
That's being held. Pending, yeah, the jury verdict on the conversion came back at 56,000 or something, plus interest. But that's on appeal now, so we can't get the 20,000.
Is it in the record, is there a registration for the Toyota or the, or your opponent says, look, the car was registered in my client's name, and there was maybe a registration for the trailer as well? Is that in the record?
There's documents in the record. However, in the case in chief, the defendant was...
Case in chief on contempt or the case?
No, on the underlying case.
No, that's outside our record.
Well, all right, so the documents that she produced were never produced in the other case, even though she was supposed to produce them, if you follow my argument. And if you read Judge Wren's decision on letting them in, he said, I'm aware of that. I'm aware they weren't produced. There's an order she couldn't produce any other documents than what she did. This basically wasn't one of them, but I'm going to let it in for this purpose. It was a copy. There's no original of any document. She does not have an original title.
Was the copy put in evidence in the contempt proceeding?
Copy of, I think it was a copy of a registration. I'd have to go back and look at the
okay.
At the appendix. So, and the question, I think that falls under the credibility issue, where he found neither her nor Crisidlo to be credible because of the issue of that piece of paper had not shown up anywhere in
That's not what the judge says. He says he doesn't find them credible on this point. He doesn't say because of this document and how.
Well, no, I mean overall, he found them.
We got to stay with the record in this case. We can't be trying to figure it out based on a record that was developed afterwards.
The problem is, having been involved in this thing since 2018,
hard for you to separate it out.
it gets difficult.
Okay. Well, we'll look at, see what's in the record before us.
Okay, all set.
Andy?
Well,
Okay. Wait, wait.
Yeah, I do.
Hey, sorry, he's got one more question. Justice Engler's got another question.
So, with respect to Krasidlo,
Yes.
you say that was clear error on the judge's part, finding that he didn't have
Yes.
notice.
That's my position, yes. Based on the case law, based on Kivlakian, based on Menda.
Why is it based on the case law? Isn't it just, I mean, he makes a finding that he didn't have notice.
But that's clear error because he had, for contempt, you don't even have to have a written notice. You can be verbally under the Menda.
Doesn't he have the discretion to say, I'm not going to find him in contempt, even though, I mean, you know.
Well, that'd be different. If he said, I'm not going to find him in contempt.
That is, why is that an unreasonable reading of what Judge Wren said?
Because he had notice of the order, and that's exactly this is exactly what happened in the Kivlakian case.
I assume in Devlakian there was a finding of contempt.
There was, and the issue was.
So it doesn't mean the judge has to find contempt, does it?
I think it's error. The error is in saying that he didn't have notice of the order, when in fact maybe
It says there's an order, and it quotes it.
Right. That's right. I mean, and the other argument I would make is that at a minimum it requires reasonable inquiry. When you read something like that, say, geez, you know, maybe I should find out.
What's our standard of review for the judges? I mean, it has to be clearly erroneous, right?
What, on the factual finding?
Yeah.
I think it's an abuse of discretion because it's not. He says that the order. He says he didn't have notice of the order because it wasn't in quotes.
The judge found that he'd never seen the order. That's all the judge found.
He'd never seen the actual order, but he says the letter didn't put the relevant words from the order in quotes. Now, you know, I don't know that makes any difference because the language is there, and he knew about it.
Court finds that he did not have actual notice of the court order as to either time frame.
And actual notice doesn't mean you have to see the order itself.
Well, he doesn't say that. He doesn't say that that's what he means.
But then it's contradictory because.
Well, it may not be when Judge Wren knows that there might have been a lot of communications going back and forth between attorneys to the clients, going back and forth, and who knows what an actual order was and what a lawyer was arguing was a point, like whose property it was.
Well, the letter that was delivered specifically said, or quoted, not in quotations, the specific part of the order about dealing with the items. And if you're going to say, under the case law, that's good notice for contempt. So if you're going to say that he's not in contempt for that reason, you've got to have an underlying explanation for why that's not noticed as the under the rule and under the cases that came down, and that's what I think the error was.
All right. Well, great. Thank you both for your arguments. The case is submitted. And one more case for this afternoon now. 24P476, the estate of Robert William Allard.
Good afternoon, Your Honors. Thank you for the opportunity to appear before you today. My name is Andrea Kramer, and I have the privilege of representing appellant John Allard. Ultimately, the question before this court is whether the notice of appeal that was filed from the probate court's decision in Mr. Allard's, John Allard's, I'm going to use first names since there are so many Allards, John Allard's challenge of his brother's will was valid, such that he could go forward with his substantive appeal. At a more granular level, and there's a lot of legal rules in this. The issue is whether the post-judgment motion for attorney's fees of a group of parties known as the will proponents pursuant to Mass General Law 215, Chapter 45, and Mass General Law 231, Section 6F, was a Rule 59E motion to amend for purposes of Rule 4A3 of the Rules of Appellate Procedure. Before addressing that issue, it seems that there is a preliminary question regarding the standard of review. Would you like me to address that?
Sure.
We have argued that the standard of review in this case is de novo, or plenary. And that's because the issue, as I phrase it, is a pure issue of law. My opponent has said that the issue is one of discretion, abuse of discretion, because the lower court, the probate court, had discretion. So
Lower court had discretion to dismiss an appeal?
No, the court did not have. Well, the court sometimes
The
has.
argument they're making, the lower court had discretion to dismiss an appeal?
Well, I think it's not for me to phrase their argument, but as I understand their argument, it's the lower court had discretion to set the timing for when to file a motion for attorney's fees. We don't dispute that. That the court had discretion to grant or deny the attorney's fees. We don't dispute that. It's not even an issue. And that because of those pieces of discretion, when the court called the motion for attorney's fees a motion to amend, that was within her discretion. That's what we dispute.
What was the authority that they said that the judge had to dismiss a notice of appeal?
Her discretion. And let me be clear. The judge herself does not believe that she had discretion. The judge's order says, it does not these exact words, but she basically says, Rule 4 says you shall dismiss it, so therefore I am dismissing it. She never says she's exercising discretion. In fact, when a judge exercises discretion, as you all know, the judge usually makes findings of fact, and the judge didn't make any findings of fact.
Does the rule say shall dismiss? It just says no effect, right?
I'm sorry?
The rule doesn't say shall dismiss, it says no effect.
Correct, you're right.
I don't want to hide the ball on you or anything like that. In a couple of cases, the SJC and we have given no effect to the no effect rule.
Yes, Your Honor. In fact, you were on that case along with Justice D'Angelo.
That was an unpublished one, but the published one is Tachi Building Corp., 101 Mass 133.
Okay.
And the SJC is Roach versus Malika, 481 Mass 164.
Yes, Your Honor.
Why aren't those in the briefs? Why aren't we talking about the fact that we're not following Rule 4C anymore?
Oh, I guess I hadn't understood it exactly that way, and I must confess that the reason...
More accurate, we have cases that say we're not going to follow 4C, including an SJC decision which goes on and gets to the merits anyway. I mean, isn't that one of the things we should be talking about? The other thing, because Judge Massing doesn't want to hide the ball, I won't either, is a rescript opinion written by someone I know very well called Yam against Mall at Liberty Tree, which says, judge can't dismiss a notice of appeal for any reasons but those in Rule 9 and 10.
I would say, Your Honor, you are exactly right. And why we're not discussing those, I guess somehow in trying to figure out that this was a Rule 59 motion, I went down that road and I missed those other ones. I confess.
The issue you have is a really interesting issue. I agree, and I'd actually thought about it when I was practicing. I get that.
Well, I do have a question about it, though, which is, I mean, how does an attorney fee order not alter the judgment? I mean, there's a piece of paper that says judgment, and then if you get attorney's fees, it's going to be amended to say attorney's fees on it, right?
Yes, and I've grappled with that, Your Honor. And the thing is, it doesn't really amend the judgment. The judgment is about the liability, and then this is and about the remedies. And this is kind of a remedy, but the best I have been able to figure out is that the courts have peeled apart at some finite level, very low level, the difference between sort of the usual remedies we think of and attorney's fees, which are something different, which they also distinguish from costs, which are more like remedies. So they say costs are in the actual judgment, but attorney's fees are not. Now, for efficiency, courts can roll in the attorney's fees into the judgment, but they don't have to. And if they do, there has to be a notice of appeal from both the attorney's fees part of the judgment and the substantive and remedy part of the judgment. They actually have to be both
Separately appealed?
separately appealed. They go on the same track, they have to be in the notice.
That's Massachusetts law that says that?
I did see that, yes, in cases, but they're in the same notice, but they have to be, they can be in the same notice, they can be on the same track, but you have to mention the attorney's fees.
One is a judgment, and then the other is an order that you're appealing
Correct,
from.
Your Honor.
Cases have suggested you need to say both?
Yes.
But you won the attorney's fees motion, so you wouldn't appeal that.
No, I certainly wouldn't. I may miss a case, but I don't appeal judgments, I win. Orders, I win.
Right. And although technically you should have put another appeal for the underlying judgment at that point, technically.
Well, I guess that's the question. I don't think so. It would have been a better policy, and apparently my ethics and malpractice attorney says, yes, that is the first piece of advice she gives to everybody is file a notice of appeal early and often, right? But when I saw that, having not been I wasn't the trial counsel, I came in as the appeal. I saw the judgment. I filed the appeal. The other attorney was handling the attorney's fees, and honestly, I did not think that an attorney's fees motion was a Rule 59 motion. I did not go look at a preliminary order, but I knew that there was these motions for attorney's fees, and I looked at the case law, and the case law said this is not a Rule 59 motion, so I didn't file a second one.
How did that play out in the lower court? Now I'm interested. How did that play out in the lower court? Your opponents filed a motion to dismiss the appeal, and there was an argument made that said, oh, no, 4C doesn't apply to a subsequent attorney's fees motion.
Correct.
And the judge said, I can't figure it out, but it looks to me like it does, and therefore, since no notice of appeal was filed after that, I'm going to dismiss?
Well, I wish that it might have been that the judge said that she couldn't figure it out. In fact, what it was that we went for the argument, and she says on the record, because you have the transcript of the hearing, since my opponents included it, and she says, well, I haven't actually looked at your briefs yet, but it looks to me like it's a motion it was a Rule 59 motion to amend because I called it that. And she says that 4 times. And then she actually says, well, that's how we do it in Barnstable. And so...
Because in her pretrial order, she said, you shall file a motion to alter or amend with respect to attorney's fees. So because I called it one, that's what it is.
Correct. And so she says that she will take under advisement the cases that I actually handed her at the hearing. And then she issued an order where she addressed none of them. And she just simply said, essentially, I called it a motion for a Rule 59 motion, therefore it is, and therefore I am bound by Rule 4. And so she doesn't really exercise any discretion, so that whole argument about discretion really doesn't have any role. But I'm more than happy, Your Honor, to go with YAM and the not applying Rule 4C.
Well, I guess the only question I've got in my mind after hearing that is, do you have to argue to her, hey, you can't do this?
I did, yes.
That you, trial judge, don't have the power to dismiss an appeal, except for very specific reasons, which are identified in Rules 9 and 10.
And I guess that's basically, that was the argument I made. I said, Your Honor, it's not a Rule 59 motion. She said, but I called it that. And I said, but you don't have the right to do it that. I did argue that. It's in the transcript. So, I said, I understand. I mean, it's a little bit difficult when you're before a judge and you're trying to be respectful. I said, I understand you do it that way, and in fairness, the case that I mentioned before that Justice Massing and Justice D'Angelo had decided, the Henry Guthrie case, in that probate court also they call it a Rule 59 motion to amend it. It appears to be the practice. It appears to have been the practice for the last 40 or 50 years. Nobody apparently updated it when the Supreme Court and the Massachusetts court said it's not a Rule 59 motion, just as they still have not in Barnstable.
Something different, actually. They're much broader than that. They're saying, we're not going to follow the rule. That's what we've done more than once now.
Just to be clear, what we're fighting about here is whether you, on behalf of your client, can appeal the challenge to the will.
Whether I can appeal
whether you can appeal the challenge to the will, right? That's the underlying issue that you're trying to appeal here is the you lost, right?
At the trial,
right?
correct.
The will was probated. You're challenging that.
Yes.
And if you win this appeal, you get to bring that appeal.
Correct, Your Honor.
Right.
And I'm sorry, is there something I need to address?
No.
I don't think so.
Okay, thank you.
We'll give Mr. Bowers a shot at it.
May it please the court, Anthony Bowers on behalf of appellee Nathan Allard. I have Attorney Coles and Attorney Sabat with me representing the other appellees. If it pleases the court, I'll start with that legal standard. And yes, you mentioned the dismissals under Rules 9 and 10 does give abuse of discretion to the judge. And also the SJC in the adoption of Patty said that a Rule 4C extension of that deadline would also be reviewable by abuse of discretion. So it's only logical that would follow that.
Stop. Is there a case upholding a dismissal by a trial judge of a notice of appeal on that basis?
No, there's not under Rule 4, just under Rule 9 and 10.
Okay. And are you familiar with the decision that I talked about? It's called Jan.
I am not, apparently like Attorney Kramer, I can miss cases as well.
Okay. So in Yam, there was a voluntary dismissal in the middle of trial by the plaintiff. And then there was an effort by the plaintiff to appeal from that dismissal. And the judge said, well, you can't do that. I told you that if you've dismissed this voluntarily, you're not going to be able to appeal. And actually, with a good bit of back and forth, including that the matter going to the SJC, who sent it back down to us, we came to the conclusion that there is no ability of a trial court to dismiss an appeal except as set forth in 9 and 10. Okay? So if that was wrong, then we would be the right people to talk to about that. But if it's right, it seems to me you've got that's one of the two problems you've got, but it seems to me to be a pretty significant one.
So what was the case that you said that where the judge also said under the SJC also said 4C?
Oh, under 4C, the adoption of Patty case. I think I noted it in my opinion. That would say that a judge has abuse of discretion to extend the 30-day notice of appeal deadline for up to 30 additional days.
Right.
And that's reviewed for abuse of discretion. So it's only logical that that judge could also find that that timeline had expired.
Yeah, I mean, the problem that we were confronted with in YAM is who gets to make the decision as to whether the appeal should be dismissed, okay? And so there were two issues here, right? Maybe three, but I think it's really two. One is, was it appropriate, even assuming the trial court was right, was it appropriate for them to dismiss it, or was this an argument that needed to be made to our court so we can decide which cases appropriately come to us?
Well, the appellant could have made that argument. Under 14B, they can bring it to a single justice and extend the notice of filing deadline for up to 1 year upon a showing of good cause.
Instead, they just appealed, and then the question is, did she get it right or not?
Well, I don't think the remedies are exclusive. I think they could pursue both.
I agree with you on that. They could have done that. But the fact that they didn't doesn't mean that they're out of court on this appeal.
Potentially not, but they had 6 months from the dismissal of their appeal until the 1 year deadline, and they could have exercised under 14B.
So that's one issue, and if you've got it, and I understand you're getting confronted with something you weren't prepared to address.
I'm going to reserve, speaking on it until I've actually reviewed it.
Okay, all right. Then the second issue has to do with the fact that there are these 2 or 3 cases now where we say, well, Rule 4C says this, but we're still going to allow the appeal to come to us, even though no separate notice of appeal was issued after the decision on a post-judgment motion.
And what was the rationale for not following Rule 4C?
You don't get to ask the questions. But I'll answer it for you anyway. And it's cited. I think it's in Attorney Kramer's brief that the reason for saying that the first notice of appeal has no effect is that you don't want us to be ruling on something that has been amended. Like it'd be a waste of our time to be doing an appeal, and actually there was a motion to alter and amend, and the judge completely changed their mind, and therefore you're looking at something ridiculous. And the court, we and the SJC say, but where no appeal has gone forward, the purpose of that rule isn't being served. Well, and I think out of fairness, we'll give both sides an opportunity to file supplemental memoranda instead of having to fight a letter. We'll lay out exactly what we're talking about and give you an opportunity to respond, because I know you haven't had that.
I would appreciate that, and I would note that the converse of the ruling in the lower court, had it had been allowed and the fees would have been added, we certainly would have had a notice of appeal, another notice of appeal here on the fee issue itself, and potentially on the whole case. And I think that's really the streamlined process the lower court was looking for here.
So if there'd been, suppose the fee had been allowed and they filed another motion, notice of appeal, I mean, your argument would be, it wouldn't be enough to say we appeal, under your argument, it wouldn't be enough to say we appeal just the fees. You'd have to say, and we also appeal the underlying judgment.
Well, I mean, that's a hypothetical, but I mean, it depends on what the notice of appeal they would have filed. I mean, there's no. But
I mean, if the second notice of appeal didn't say the underlying judgment, you would be your same argument. That first one is no effect, and they haven't appealed it.
Potentially, depending on how the notice of appeal is written, that certainly could be the case.
But okay, so going to the actual issues here, isn't it really elevating form over substance to say that this is a motion to revise to amend the judgment, alter or amend? This is a motion to alter or amend because I said in the pretrial order, you got to file a motion to alter or amend.
Well, that, Your Honor, and the court was quite clear that that was her intent. She said, that's the way I deal with the fees in these cases. I will take the motion. And she said a motion to alter or amend, so that means, don't forget, Rule 59E has a 10-day deadline. Rule 4 has the 10-day deadline. We complied with those requests. The motion was titled as a motion to alter or amend. The opposition from the appellant was titled as an opposition to a motion to amend. The judge ruled on it and stated she was declining to exercise her discretion, which is clearly a Chapter 215 case. And the rules are pretty clear as to what tolls and resets the notice of appeal statute, given the rule the way it's ruling, irrespective of how this court has declined to follow it. The rule's pretty clear, and it says that the earlier notice of appeal has no effect, and it must be refiled.
It's not just us. The people downstairs said it first.
Said it first.
Okay? They had a case. I mean, this is, I practiced law for a long time in civil cases. This is a problem, this trap for the unwary has been around for a long time, right? You file your notice of appeal and you don't realize that there might be a problem if there's post-judgment motions and a ruling on the post-judgment motions. In that SJC case, they had that situation. There had been a prior notice of appeal. There was not a subsequent notice of appeal filed after the ruling on the post-judgment motions, and the SJC acknowledged the rule exists and said, but, this is important, we're going to go on and address it.
I assume that's like a no harm, no foul type analysis. That here there is an ongoing administration expense. There's ongoing legal fees. You got an appellee here who's effectively promoting a will that disinherits him and has spent a lot of money doing so.
Are you arguing, fairness because their notice of appeal was filed too soon?
Well, no, it's a legal nullity according to the rules, and I understand the SJC, and I'll certainly review that case and brief it after this request.
Is there anything in this case to the old civil axiom, it's the law of the case. When the judge acts a certain way, the parties act a certain way, that's the law of the case?
Well, I mean, the Henry King case, it gives really broad discretion to the trial court judges on the imposition of attorney's fees. The Henry King case says, and specifically citing the Chapter 215A, Section 45, and not to mention the statute in Section 39 says the statutory is very broad discretion of the judge. It says at any time, irrespective of the pendency of the action, it can assert fees upon request to any interested party in a probate action. That's really broad, certainly, and also there's one other case I wanted to bring up, and it's actually cited by the appellant here on page 32. It's the Society of Jesus case, in which they say there is no rule for timeliness of attorney's fees in Massachusetts. It's up to the discretion of the courts.
But wouldn't that, if that's true, wouldn't that suggest that attorney's fees are different with respect to whether or not a request for fees tolls the timing of the notice of appeal? I mean, if you can file at any time, surely there's got to be, you don't sit there wait, well, maybe they'll file for fees in 2 years, so they haven't blown the notice of appeal deadline?
Well, the Rule 4 and Rule 59 have a 10-day deadline, and if it's not filed, it doesn't toll. And if it's not filed, I would argue it's not a motion to amend under our civil procedure rules. So therefore, we wouldn't be here if it was filed outside that 10-day window. The rule's really clear.
So if you file a petition for fees under 215-45 and 6F a month later, then it's not a motion to alter or amend, but if you do it in 10 days, it is?
Yes, and that's because the intent was to amend the underlying judgment to include the fees. And even the White case, the Supreme Court case cited by the appellants, actually advocates for a streamlined procedure. And it says, moreover, the district courts, speaking of the federal system, remain free to adopt local rules establishing the timeliness standards for the filing of claims for attorney's fees. And of course, the district courts can generally avoid this piecemeal appeals by promptly hearing and deciding claims for attorney's fees. Such practice normally will permit appeals from fee awards to be considered with any appeal from the final judgment. And I think that was the trial court's position here. That's how the will proponents were acting, was for that very reason as well, that if there was a fee award, it could be executed upon with the underlying judgment.
If you want to, you have some more time if you want to use it.
I do have a few minutes, and like I said, the briefing by the appellants, they don't cite a case in which this fee, with one exception, where a fee request was actually made within that 10-day deadline, and that was the managed air systems case, and it was a summary judgment and a fee request the next day, so it was clearly within the 10 days, but it was later withdrawn at the hearing with the permission of the court and refiled, I think, a month later. So even that case was not properly within the 10-day limit. And the counter-argument was it's no longer a 59E. It can't amend that underlying summary judgment. And in that case, they allowed it based on the Society of Jesus. They said the court has the discretion to set these timelines, and we're going to allow it to go through.
Okay, well, I mean, we definitely understand the arguments. It's a very interesting legal issue, and the legal issue that you guys both did a good job of briefing. So appreciate that, and we will get sent. Watch your emails for an order on further briefing.
Well, thank you for the panel's time, and I'll rest on my brief from there. Thank you.
And with that, we're going to adjourn. I want to thank the clerk, the timekeeping, the court officers, and we'll be in recess. All rise. Adjourn, whatever.